Good morning, good morning, good morning, everybody. Welcome to Twisted Tragedies, where we follow all the twists and turns wherever they lead. I am your host, Elise, and today is Wednesday, day 11 of the Karen Read trial. Before I get started on all of that, do me a favor and hit that like button, hit the subscribe button, share the video with friends, share it on your Facebook, on your X, in a Discord, in our Discord, so people know we're here. I forgot to do that this morning. That's my bad. And if you can, it's always helpful to help out the channel. We rely on donations from our viewers, our amazing viewers like you, to keep on trucking along. We are not monetized yet, still waiting on YouTube. Hurry up, YouTube. So this is the only form of donations we can get. And we have quite a few now. We have Cash App, PayPal, Venmo, Revolut, Chime. We have a Apple Pay link, and there's always that wonderful option of e-gift cards. If you would like to contact me just through email, it's twistedtragedies3@gmail.com. All right, let me take the big one down. There's a ticker that scrolls on the bottom of the screen that you will see for donations throughout the entire stream, so that if you need to stop, you can pause and get the information. Or you can just ask in the chat, and our wonderful mods will do the best they can. Okay. Hi, Leah. Good morning, everybody. Good morning, good morning, good morning, good morning. Okay. Cliff Notes version of what happened yesterday. Well, we had a meteorologist yesterday. That was one of the experts. And Alessi was the one who was cross-examining the meteorologist. It was, like a form of torture to have to listen to Alessi, of course, as we know. And at one point, he didn't really even know what he's supposed to be asking this, meteorologist, although I heard that Alessi is an environmental lawyer, so maybe you should know some of this, but he's fumbling asking questions and not getting the answers he wants, of course. And he asks a question and he's like, do you understand? And the meteorologist is like, I didn't understand any of that sentence. Like, essentially saying to Alessi, like, buddy, I don't know what the F you just asked me in that word salad. Like, so that I think wins the day on Funniest Thing Said. But he was very polite. The meteorologist, he's an older gentleman, but he was very polite, super nice, very credible. Hey, Karen. So I find it funny, that we're dealing with a lot of these really credible witnesses, and then you go on X and the cult's like, no, they're all terrible. They're awful. They just got destroyed. And I'm like, Planet Delulu, can you come get these people, please? When you rely on a sewer turtle for your daily information and to give you legal takes, the man still thinks that his charges are magically going to drop out of the sky and go away if Karen is found not guilty. That's not a thing. Like, he still committed a crime when they were witnesses. What? I agree, Leon. I think yesterday was a complete Commonwealth win, as it has been this is the Commonwealth case. Of course I can't beat him. This is the Commonwealth case. You know what I'm saying? So I'll just, by default, just start sending it to you in the morning. It would be probably easier. But I mean, come on. I've said this so many times, but I almost feel like at this point, is the defense purposely throwing this? I don't understand. They haven't changed up anything that they've done for this second trial, knowing what they know about the jury and what the jury thought about certain things. They didn't change it up. I know. Imagine. We did have Trooper Nick Garino come back and read some text yesterday. That happened. So there was, those were some stuff we've already heard. It's stuff we've already heard, but interesting nonetheless,
What's up?
Hey.
I think the reason why they didn't change anything up is because they can't change anything up, because if they actually change anything up, it makes all their fan base angry at them, because they will realize that they've been lied to.
Yeah.
I was listening to this, I think this is this channel, this guy, he's kind of like in our position. I forgot his podcast, and he was talking to this other gentleman. I'm trying to remember what the name of the show was. I'll pull it up. Let me think about it. I gotta go through.
Somebody might have sent me this. I have it. I just didn't have a chance to play.
Hidden Killers with Tony Broski or something like that.
Maybe that's it. I don't know the name of it. I just have the clip.
So I was watching it, and the guy actually, like, the guy who was talking to him was just like, yeah, I could believe, like, I don't believe it's a plan. Like, in the beginning, I didn't believe it was a planned situation. I believe it was like a bar fight, type of situation. And the defense kind of lost me with this whole, conspiracy angle. And I think that's the problem. It's like if they would have just stuck with a simple idea of this was like
an accident.
Like they would just panicked and they threw him in the, what I mean? And they were just like panicked and they weren't thinking. But I think they overextend themselves in the defense in this whole conspiracy that everyone's covering it up. And this was a planned murder. And they were just, they planned it off the get-go at the ball. Yeah. And I just think that's why I think they're losing a lot of their support, because it doesn't, now that they're listening to the defense, because it doesn't make sense.
I mean, look at all the people that, like, less people came outside than what was, like, there after the sewer turtle had his giant fit. Like, he had that giant fit about, you better get down there, you're all dead to me, blah, 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 blah. And then less people came the next day.
Well, I mean, people don't appreciate.
Yeah, Karen, Francesca loves you, Karen. I just want to throw that out there. I was telling Francesca I'm friends with Karen from True Crime and Wine. Talk to her almost like every day via text, and Francesca loves Karen. So look, there you guys are together. You guys can talk. See that? Amazing. I love it. Go ahead, BT. I'm sorry.
Well, I know Karen Reed loves wine. No, so we all know that.
Karen Reed does. This is the good Karen. This is the good Karen from TikTok.
I know. I think I know this person. Yeah, but I don't know. I think that the idea is that they're losing even their own support by like overextending this whole conspiracy, planned murder, and I think the only people that would actually believe such a ridiculous theory is people that drink the Kool-Aid.
Yeah. Hi, DJ. I mean, it is. That's exactly it. Is we're talking about people that will just take in whatever they're being told. Like, I encourage my viewers to go get information other places. Don't just listen to me. Go check it out for yourself. Please do it.
And an interesting point I hear from a lot of people who are kind of like listening and they're not really believing the witnesses, that they feel like the investigation had issues in the beginning, that there were problems, and it wasn't a good investigation. And I say that this is like, okay, let's say we go with your valid point that the investigation wasn't great.
Wasn't perfect.
Right. Wasn't perfect. Based upon the evidence, are you just going to let this lady go because the investigation wasn't like perfect?
Well, that's the other problem, though, is some of the evidence, like, you can discount all the evidence that Michael Proctor touched if you really want to, and just boil down to John's phone records and the car data. And that
Karen's own words.
Story.
And Karen's own words.
So you can discount everything that Michael Proctor touched, but he didn't touch those things. Those things can't be altered. The car data can't be altered. And the defense is the one who did the chip on, chip off in the first trial. And the experts are standing right there together when it's done. So John's phone records and Karen's car alone show her guilt. So you can discount everything that Michael Proctor did and still prove guilt. And then there's that misconception that people think intent needs to happen for murder too in Massachusetts. No. It does not. It's not required.
No, it doesn't. Another thing is like, I think Karen Reed is very unsympathetic. She looks like more like Gotti. She acts like, come at me like a mob boss. She's got, and I'm gonna explain why I think that is, because she dresses up like a mob boss. She goes up on there. She has capos who basically spread misinformation and get money illegally via gambling, which is one of the things the mafia makes money from, which is illegal gambling, and which is, I'm saying, the raffles, which are illegal. And then she proceeds to do witness intimidation on people that are testifying against her. And she secretly has conversations, just like a mafioso boss that would have went in the old days in the 90s or the 80s. We're using a payphone.
Back in the day, they used like notes, and it was like burn it after you read it.
No, like notes, but like a payphone, or they would be like they're covering their lips, and it's the same
10
thing.
10 seconds or less on a phone, so you can't be tracked. Now it's Signal.
And now she has a bunch of sleazy attorneys. How is she any different than a mob boss in this criminal enterprise to get this woman off from her charges? And
I honestly don't know why they haven't charged Rico. It applies. Charge it. The feds love Rico. Like, use it.
Well, it seems like the feds are very friendly with Karen Reed. Let's just say that much.
Well, not anymore. Well, I'd say that relationship dissolved now. But yeah, you're right. They did have a very fluffy relationship. and eyes are on that now, because as it should be, that should be investigated. There was some serious wrongdoings happening there, and I believe Josh Levy needs to be held accountable for what he did.
Absolutely. I think Alessi completely lost the plot with the weather guy. I don't think I think that he thought he could just like trip him up or something. It's just like, you're boring the fucking jury. Like, everyone knows the ground. Yeah. Everyone knows the ground was hard. Let's just move the fuck on. Like, there's certain victories you have to just give and not waste the jury's time.
Well, I mean, you're wasting the time going about how many inches of snow were on the ground. All you're doing is proving that because there was dirt and grass underneath John, then that's where he laid there from that time on. That's all you proved. Like,
yeah, it's like, come on. It's like, stop questioning witnesses that you're just not going to win an argument with, like the weather guy.
No, the other guy's like, I don't even know what. I don't understand a word you said in that sentence. He said that was the funniest thing ever, and he was like super polite about it too, but it was hilarious. Like,
yeah, and that's the problem with Alessi. He doesn't talk to humans normally. You know, you have to break down a question that is understandable to not only the witness but to the jury. And it's like, you're not breaking it down, man. It's like, tell the jury, is the ground frozen or not? Did it snow a lot or little? You know what I mean? Break it down. I mean, that's all you really need to do. Stop with this, whenever Alessi comes up,
theatrics.
It's like
everything's theatrics.
It's like he wants to prove he's like a really smart guy. And it's like, bro, the smartest people are the people that explain quantum theory to a third grader. You know what I mean?
Explain it in layman's terms so everyone can understand. And that's what I try to do when it comes to like legalese and like the law, is explain it in a way that every person can sort of grasp, no matter who it is. Like, and it's like you going on and on and on and using words like colloquy, like, big words that some people may not even follow. Like, you're losing regular people just by trying to use big words.
Only really an attorney or someone who's been involved in depositions and stuff would know what colloquy was. You have to say, like, in our previous testimony or something like that.
Right.
But another issue is that before lunch break, he plays the fucking whole list of her voicemail, which, was pretty bad. It was pretty bad for Karen.
Well, I mean, so we got some like information from inside the courthouse that when Jackson was cross-examining, one of the jurors like huffed and puffed and said something along the lines of like, Jesus Christ. And then we had one juror that during Alessi doing like the thing with the meteorologist put their head down, like, it's just not, I mean, and then the voicemails, which you could tell apparently like, stunned the jury a little, especially the first one, because she was screaming. So it kind of like, they were kind of like, what the fuck? Like, so it's not looking so good for Karen.
Yeah, and Brianna asks an interesting question. She says, what do you think of the environmental attorney who bases arguments on meteorological testimony, trying to prove meteorologists aren't qualified to talk about the weather? Yeah, that is quite insane, actually, which is so kind of like, that is like, is pretty dumb, and he's just wasting the jury's time. It's like, if you are the defense, I don't know why they thought about this whole grand conspiracy. I don't know why they went after the EMT so hard. It's like they're getting their talking points from Turtle Boy followers and Karen Reed on how they run this case, instead of focusing on what if I was going to go with the whole he got beat up in the house theory, I would have been like, they were all drunk. Higgins was there. A fight happened. They covered it up. They moved him there, and it was like a last minute thing. That's why they did it. It was just a last minute thing and whatever.
Like,
I mean,
what? So the last minute idea was to throw him on the lawn, not the railroad tracks, where someone wouldn't have found him for days.
It wouldn't be my first defense. Like, I would make up probably a better excuse than that.
Like the whole police force, the EMTs, the firefighters, everybody's covering. An acquaintance of Caitlin Albert is covered. You know what I'm saying? Like, it's bizarre to think that a jury would believe that.
Well, they did. Well, unfortunately, 3 jurors did believe it in the last trial, or at least they believed. Like, one of them believed it. The one that's like an attorney for Karen Reed now, or working with the Yannetti's law firm.
Yeah, that one. We've seen her in action. Like, I do. So I saw somebody on like one of the pages. I think it was, oh God, I can't it was crap. I'm trying to think of which page. Oh, it was a Facebook page, but like they were like, oh, well, I was reading Sue O'Connell's notes, and I was like, stop right there. Don't read Sue O'Connell's notes. Hi, Trisha. Don't read them. I have literally had experience with her. Like, she's a literal liar. Like, you know what I mean? Like, literal. I've had the experience with the lady literally lying about those of us who went down for the first protest. She decided she was going to say we were only there to agitate. There was like 7 of us, right? Like, she never laid eyes on us, never saw us, never spoke to us. And then we had to get her to admit later on, after she said this on Canton Confidential, online on Twitter, that she never saw us, never talked to any of us, never even laid eyes on us. So how could you say that the group of, 100 or more people with pom-poms are there not to agitate, but we don't have the same rights they do? The only reason we went there is because the pom-pom people decided that they were going to go down to the VFW where the O'Keefe family was and try to get in. They said, the VFW is like, no, it's a private event. It's closed. And they're like, oh, we need to use the bathroom. And they're like, nope, private event. You got to leave.
Which
like,
is kind of...
the police are called. Like, you're heckling the family? Like, get the...
Yeah. And that's where I think it loses a lot of people that might be very sympathetic to Karen Read, is like, you're harassing the family of the victim here. It's not just... I'm against all witness intimidation. I think it's fucked up. But you're welcome to your thought process and your true crime. But the moment you start harassing witnesses, the moment you start harassing family members, you lose, man. You lose a lot of people who would generally be like, okay, I'm here to listen. And it's and what do you have now? You have a bunch of people who honestly are just rabid people that you wouldn't even trust in a local subway like a shop to sit in to eat, because you think they shit on the floor.
No, that's the thing, right? Like, yeah, Paul's in the back, but so is Nathan. So I guess, they're in timeout, I guess. Well, they do have to go with that because of the tail light, like it's unfortunate that they like think that most of us normal people are just going to buy this ridiculous theory, because the jury's lost on this. You're welcome, Rosewater. There are so few of us, I tell you that.
I think the problem with the defense is they made these big promises and they're not seeing it yet.
No payoff.
I think the best payoff, and they went too hard on certain witnesses like Jen McCabe, or they really should go, why don't you just focus on not going so hard? Because it's never good. First off, it's never good for a man to go too hard on a woman on a stand.
Right.
It's like you should always have a woman question a woman in that.
I think maybe this works like in LA. Like maybe this is the style that works in LA. But I promise
that's not the style. That's not
in
the style.
Massachusetts, we don't appreciate that. Like, to be fair, if we're going to be assholes, we're the only one allowed to be an asshole. You outsider, not from Massachusetts, don't get to come here and be an asshole to people. You can go F off on that. Like,
and the problem is like, people have said like, all you need to do is prove reasonable doubt. You don't need to prove your theory. But when you're pushing a third-party culprit to theory, you kind of do at that point.
Yes, you do. You have to give the jury something to believe other than your client did it.
Okay.
So they're like, the defense doesn't have to prove anything. I'm like, but if they're promising a jury, they're going to give a third party or someone else who did it, then you need to deliver on that promise if you want to win said case. Like,
you need to prove at that point, and that's the thing. If you want reasonable doubt, then you shouldn't have just started stating that I'm going to prove a third-party culprit case. You should have just said, well, their investigation was messy and they rushed to try to just grab anyone because they were being pressured politically. Right, and my client was emotionally distressed. She was shocked. She said things that she would never say. I would never have had her on docuseries or anything like that.
F no. That would have been the smartest thing.
No. I would probably be yelling at Yannetti for making that statement on the stairs saying it was a terrible accident. Bullshit.
What a dumbass. But I do think that he's probably the smartest one in the room at that point, where he was like, I could probably get her off on a very slim to nothing like jail sentence for an accident, or she could have been found not guilty because it was just a terrible accident. But everything she did after that sunk her shit. Like,
are they gonna give this woman a roller? Jesus Christ,
dude, it's so like she's rolling in an entire suitcase as if it's her. Like, you're like, again, you're the defendant. I have never seen a defendant do all this extra shit.
The crazy people that represent themselves.
Well, yeah, those. But I'm saying like one that seems like they're, semi put together. She dresses put together. Like, so it's like, I mean, you hired all these high-priced attorneys. If you have all these high-priced attorneys, what the hell do you
you gotta. The point is, you have to. You might need to move. The point is, you're trying to try to convince the jury you're not a crazy woman that will get drunk and back your car into your boyfriend. So you want to dress very like how Jen McCabe is dressed. You want to dress like that. You want to kind of look,
Hey there, Karen Reed.
You don't want to look menacing. You don't want to look intimidating. But the problem is like you look like a mafia boss. It's like not a good look. And also another issue is that Mr. Jackson basically proceeded to claim that they were in this lovey-dovey relationship. And then it just, every time fucking Hank plays a clip, it destroys any sort of ground he makes with these witnesses. Because it's like, oh, they're a lovey-dovey relationship. I fucking hate you, you pervert. It's like, okay, this does not sound like a lovey-dovey relationship.
But now we know like what that pervert comment was. And that was everything that was triggered by that was that Bella's mom's house. That is what was triggered by that. That is what made her go cuckoo bananas. Bella's mom's house comment. Just the directions.
Yeah, and I personally thought it was the Higgins being there, and that she was going to be outed.
I did too at first, but now we know.
Yeah, but the 52 calls.
Leon said that he saw the call yelling at the lawyer, because he apparently said the Commonwealth had a great day yesterday.
Which lawyer, in my opinion, is obviously biased. I think he's biased. But if you sat there and said they didn't have a good day yesterday, then you're like a Melanie Little, like literally, like you are completely eating, like you are not being truthful at all. And you know what I mean? Like, and you got to realize, like,
I love when people say stuff like this. Like, look at what Jennifer's saying. Like, Nick Rocco was on court TV saying the jury's stone cold and had no reactions to the voicemails or clips. We know differently because we have other people that are actually in the courtroom that, like,
and the
aren't trying to lie.
And I think Karen Reed's own words is destroying the defense, because if they didn't have those clips, they could put a little bit of the reasonable doubt on that I hit him, maybe. You know what I mean? You could put a little bit of that, but when you have your client just say, absolutely, I did say that. Absolutely, I was drunk off my ass drinking Tito's and whiskey or whatever the fuck she was adding onto that drink.
Like,
I mean, and then you undermine your defense by stating that, I dropped, he was there where I last dropped him off, which I thought you saw him walk into the house.
But then she also made the statement to Jen, I left him at the waterfall. Like,
I think she needs to testify. I think if she
ain't gonna, we know that.
She needs to testify. I mean, if she does not testify, I think the jury's going to hold it against her 100%. Because if you're in this docuseries, you're playing these clips and you're unwilling to testify, what are your thoughts as a juror at that point?
It's true. It's true.
And how are you going to clear up the miscommunications and docuseries are being taken out of context if you don't go on the stand and testify? And to me, it's like you're willing. If I was on a jury and I seen these clips, and then I looked at the lady and she's not willing to testify on her own behalf on her own murder trial, but she's willing to go on Dateline and docuseries and all this stuff, then I'm going to be like, whoa, that's not good. I'll just take her word for it. She basically confessed on the video.
Well, it's kind of like forcing her to testify if she wants to explain herself. Otherwise, she's kind of screwed. You know what I mean? So it's like testify and get cross-examined and get screwed further, or shut your mouth and don't testify and let them think exactly what you said.
And I know people say like, oh, the jury's not supposed to hold it against a witness for not testifying, but
they're not, but they do. Let's get real.
And the fact is, if you have like literally clips of her on TV shows, it makes you wonder. Yeah, it makes you saying these incriminating things, you're going to use that. I'm sorry. It's just how it is. Human minds work that way.
The bright pink bag, I don't know, but I would love a bright pink bag. You know me, I love the color pink. She's not ruining it for me.
Mm-hmm.
Like, she is kind of representing herself. Did you guys see the whole like little powwow her and Jackson had while he was still on cross? But at the end of it, like,
Scorpio
says, like 2 minutes arguing back and forth, and he went back, asked a very dumb question, and then ended it. Like, which was clearly forced by Karen. Like,
Scorpio says, can John's family sue these Lawtubers because it's disturbing? I think No, I mean, like, honestly, they haven't
Will they is
accused.
a whole nother thing.
No, 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 no,
Can
no, no.
they? Yes.
Let me just say something. I don't think they could sue them unless they said something defamatory, like something, an untrue statement that
Well,
they
if they
knew
call
that was
them murderers,
that
yeah, they can.
that they knew was untrue. Like if I said Karen Reed's an alleged murderer, can she sue me?
Alleged.
No.
Said alleged though.
Yeah, and I don't think unless they called her like they call these people are murderers and they defame their business, but you also have to show damages and stuff like that. I don't think they could sue.
Perpetuating that they're murderers getting away with murder. I mean, yeah, you can be sued for it. That's why Aiden's going to be sued for that exact thing. So
No,
let's just
Aiden's going to be sued because of other things, like what he did
going
on
to be
the
sued for a lot of things. A lot. I should be clear. A lot of different things.
I
But
need to
that's
complete
part
my
of
point. I need to complete my point. My point is that just because you're on YouTube and you cover true crime and you have a different opinion, I don't think you could be sued. The only time you can really be sued is basically, let's say you state a statement that you knowingly know is untrue, and that you basically, like a state, like an opinion is a statement of fact. So, like, if I came in there and I accused you of killing your boyfriend, for instance, your boyfriend's dead, and I just keep on doing that, and this caused you emotional distress, and you lost income, you might have lost your job. That is what you can sue for. But if, like, you got someone like the lawyer who knows that has an opinion, very negative opinion on the case and it's covered, I don't think you could sue that guy.
it. It depends on what they say. Obviously, it depends on what's said. Whether they're saying like that's their opinion or whether they're stating it as if it's a fact and then doing things like,
But you could probably sue like the Glare. The Glare could be easily sued. Turtle Boy could be easily sued. I've never seen Melanie Little. She could probably, I don't know.
She can definitely be sued. Nan can definitely be sued. You want to know who else could be sued?
DUI lawyer.
Yep, the DUI guy. He tried to get into the court with a fake press pass. That was real cute. And it got thrown out.
I think they stepped over stepped over the line with their coverage. Because they're not like Emily, like Emily D. Baker or Lawyer No
Randy
or State.
Churchwell. She definitely can be sued, especially because there's that message floating around where she tells people she knows that she, thinks TV is a piece of human garbage and she doesn't really believe the nonsense, but these people pay her bills. So she's going to keep her mouth shut.
Yeah, but I'm just saying, like, there's a standard, and I think, like, the first off, you have to get over the protective speech thing, and you have to basically be careful because some states have anti-SLAPP, so they might try to do an anti-SLAPP on you. Yeah, so they might try to do an anti-SLAPP on you, and you might have to pay their attorney's fees. So you got to pretty much know you have a dead to right case on it.
Yeah, I mean, let's make something abundantly clear here. The sewer turtle is going to be sued into oblivion, and a lot of them are waiting to drop their lawsuits until this case has a resolution.
Oh, I'm just B10. I jump around a lot in panels. I hang out in a lot of very interesting cases. Let's just say a lot of them. I follow a lot of, let's just say a lot of the drama surrounding true crime and also the situations that evolve around content creators harassing families. We cover that a lot.
Shitty stuff.
And there's a lot of them, unfortunately. And
what's going on with Bullhorn? She go to jail yet? No.
She might have gotten indicted on the grand jury for her witness intimidation. She might have been indicted 2 days ago for basically harassing and stalking a family.
She didn't learn her lesson.
Tennessee don't play, and they might have been. They took her to the grand jury. We don't find out until a couple of weeks. But she might have been indicted, and she might be facing felony charges to be prosecuted for that. And if you don't know, it's the Sebastian Rogers case. So
the family, she's like harassing the family, and then judge was like, "Hey, this family does not exist to you anymore. You will leave."
And she continued.
And she continued on.
She believes that the family is guilty for the disappearance of Sebastian Rogers.
She can believe whatever she wants, but you're stalking them and act like is a whole nother level. And this is what we're seeing with the sewer turtle. It kind of mirrors it a bit. With the kind of behavior, and just spitting in the face of justice and the judge. Except apparently the judge is here to go like this and keep taking it.
Duty Ron. I mean, listen, I like Duty Ron. I'm not gonna. But I do disagree with Duty Ron about this case. But I do like him. I think he does great opinions on certain cases. Like, for instance, I liked how he kind of called out Betty for what she was, and I just disagree with him. Maybe because I think until you're put into a situation like the Canton PD were put in, that you can't really judge them on that. I mean, like, in the end of the day, everyone could be like, an armchair quarterbacking, but in the end of the day, I think there was mistakes, obviously. But would it, you know what I mean? would I basically throw the entire investigation out because there were mistakes in the beginning? Absolutely not. I think
no
that
investigation is perfect. Let's just make that abundantly clear. It's just not all dragged out into public usually. Usually it's small little things, you know, but no investigation is ever perfect.
yeah, so I think like honestly, but yeah, I like Duty Ron, but I disagree with him in this case. And I think I don't think he's doing it for the views because he disagrees. I think he's just like, as a police officer, he has a different opinion on certain aspects. And I also think he's not getting all the information, but that's just my opinion on that. But I do like Duty Ron.
I don't know. I don't know of the guy, to be honest. I'll have to look into him because I do, you know, just because they have a different opinion of me, especially even on this case, doesn't mean they're a bad content creator. It depends on what their, you know, why they believe what they believe.
He's 100% against witness intimidation. He thinks Aiden's a piece of shit. And he might just, I think he just really just disagrees with how the beginning of it. That's why I try to like, I try to be fair to people.
Put yourself in their shoes. That's what I do.
Yeah. And I got to realize that not everyone's going to think that a lot of people are going to have the opinion the investigation is fucked up. And they might think that could be a reasonable doubt. And they're not Turtle Boy supporters or they're not crazy people.
There's actually quite a few people that believe that she should be found not guilty. And I don't mean innocent, but not guilty. And hate him. Can't stand him.
And as a person that is trying to look at facts and try to have some empathy to people, you have to not be like the Turtle Boy people where you're like rabidly attacking anyone that disagrees with you. You try to listen to them and you try to have a conversation with them. And if they disagree with you, they disagree with you and you keep it moving. And
I've had so many conversations, even great debates with people about this case, but civil ones where I've gotten on the phone with people and had these conversations. And guess what? We still remain friends. We might not have the same opinion. And I know I take a lot of flack for, you know, having being a friend with Sean, but me and Sean don't actually talk about the case. That's not part of our friendship. Like it just started out as just, you know, he was a retired DEA agent. I know a lot about the law. I wanted to be an attorney. Like, you know, those two kind of things jive together. And we just got interested to talk about. Now it's mostly family. Like he'll check in on me on holidays and birthdays and ask how everyone's doing. And I'll check in on him and his wife.
Yeah, I do disagree with Duty Ron in this case. I think it's pretty open and shut. I think it actually, what angers me is not just the her killing her boyfriend, but the fact that she has basically made the entire, like, attacked these innocent people and actually made a mockery of the justice system. And all these people are profiting from this circus. And it actually infuriates me when I see that, because I say to myself, you know, like, would any normal person be able to do this without money? No. I think this is a clear sign of the problems with our judicial system, where social media can manipulate juries now. It's a clear problem with money and influencing, you know, the outcomes of actual trials. And I think it's really fucked up. And I think this needs to be addressed in the future. Our courts need to really find out how to address this.
Do something, because they can't just keep doing nothing. Like they just can't. Like,
all right, I think they're back. It's in session.
Ooh, did she just say sidebar? I saw it on that closed caption. She did.
It's sidebar, and
she starts with a goddamn. All right, well, looks like we're playing it. We're playing it. I think what pisses me off the most is when I scroll past some of these grifter channels.
You could tell them. You could tell they don't believe one bit of the.
Not only do they not believe one bit of it, but what blows my mind the most is, like, they spend most of their time reading like super chats and super stickers anyway. I read mine when I get them real quick, say thank you and move on, because I know people want the content, right? Like, you want to say thank you, you want to, you know, but the amounts of donations that these people keep getting, it to me confirms that, like, people don't want the truth. They want what's salacious, what sounds good, like what's popular.
Like, drama sells.
Right. You know, then I think to myself, like, I could never be one of those content creators. Like, if I know it's not true, I'm not pushing that to my audience, because I'm responsible for anything that happens to someone because I pushed out misinformation. Like that's my, I have to put that weight on my shoulders.
It's a balance. It's a balance act because you want the medicine, just like, you know, Mary Poppins, a spoonful of sugar makes the medicine go down.
My
So you want
grandmother
to
used
add
to sing that to us when we were kids to make us take the medicine.
so you want to add a little bit of sugar in the medicine, the information, because if you're just dry like a lassie, you're going to have one person in your chat, and that's going to be you. So you want to add a little bit of information, a little bit of drama, a little bit of a storytelling, and I think that's what that even balances. Some people are just pure sugar, and you get diabetes from watching these content creators or something like that.
Pretty much. It just blows my mind though, because like you know, in a lot of these channels, some of these channels are people that make like without YouTube, like really good money. They're not struggling. They could run their channels for free if they wanted to. If that was the case, that's what I would do. Like if I had the money to do that, like I'd do that. Like, you know what I mean? But it's amazing to me that they'll just keep pushing it out. Just pure unadulterated greed.
I think in the short term they're making a lot of money, but I think in the long term it's going to hurt them, because I think you're going to get the crowd for Karen Reed, but you're going to lose your core people that watch every single case.
And I don't want that. I don't want that.
I mean, and you know, every case you're going to lose people because they're going to not going to be interested in it, and you're just going to try to grow your core audience. And I think that's what's going to happen to these people. To some of them, not all of them. I mean, I don't think it's going to happen to Emily D. Baker or a lawyer. You know, I think they're fine. I think they're perfectly fine. But I'm talking about other people that just put their entire content on Karen Reed and just simping for Karen Reed, because
you know what I think my prediction is they try to go and grift off Sandra's case, and that really hurts my heart because I've done Sandra's case twice already. I've covered it twice, and that case is absolutely heartbreaking, close to home, obviously.
You know what? It's gonna be the terrible case. It's gonna be the terrible case. That one they're gonna be on like flies on shit. The terrible case.
Yeah,
because they're gonna be like
that. It's just insane to me that like this is what people want instead of the truth. Like, do you not want to hear what actually happened? Do you not want to know? Like,
I mean, unfortunately, we live in a society that wants to lie a lot. Like, you open up a magazine and you see a person that looks like perfect, and then you see them in real life and they don't even look like 40% of what the magazine is. We live in a society of lies. People want to live in lies because the truth is ugly. And it's horrible to witness. I mean, the truth of this case is pretty terrible, that this woman drunkenly drove her car into her boyfriend and left him for dead because she couldn't be bothered to even tell anyone that he was lying on the snow, or she didn't even know, or either or. It's a terrible truth. And then she proceeded to use content creators and all herself to harass and stalk innocent people. The truth is an ugly thing, and people like to live in lies because lies can be beautiful.
Well, apparently it just, you know what, it gets me the most is like these lies have taken on a life of their own, and it moves far beyond the family you see sitting right here, the O'Keefe family and the family of the witnesses. It then moved on to anybody who supported them, their loved ones, their friends, their friends, their families, any one of us who then supported them. And it's like a giant domino effect. So God forbid you say the truth in this case, or you defend these people, you will deal with. That's why there's so few content creators, about a handful of us, that are willing to say what we know, because if you do, you know the consequence of that.
Yeah, and I agree. I mean, speaking the truth, people don't like the truth. You know what I mean? Whenever you always get, the people who tell the truth are always the ones that get the most criticism. The people that try to tell you like, well, the world is round. We don't live on a sphere, like a flat surface. We don't, like, the world is not flat.
Right.
This is how here's some medicine. They'll call you a witch. I mean, like, it's just how it is, and it's just, you just have to. Sometimes just the reward of telling the truth is just you did the right thing, and that's simple as that. And you might not get any money awards, you might not get anyone recognition right now, but eventually I think you can always feel good about yourself, because in the grand scheme of things, you knew that you did the right thing, not for money, but for the right thing.
I do, and I know that, and like that's the one thing that sort of keeps me chugging along, even when the channel's sort of struggling, is like I know, like, in the end, like, the truth is gonna come out, and like all of the people who have been hurt from this deserve justice, all of us. And I know that it's going to come. It's going to come in the form of this case, having some resolution, and it's going to come in the form of his case and having some resolution.
If doing the right
send
thing,
me a message on we've talked, but send me a message on Discord. Just try to keep it out of the chat. That's all.
Yeah, I mean, like if doing the right thing was easy, everyone would do it. So simple as that.
You're right. It's definitely not easy by a long shot. I think what's more disheartening is understanding that so many of those people, and I feel bad for, like, I have a heart. I'm a person, like I'm not a robot. Like I'm a person. And so many of those people who were lied to, like, I feel like a lot of us in the beginning thought that this was plausible. Maybe, we didn't have all the detail we have now.
You were getting information from the defense.
Right. So we had no idea. What we were told is what we were told. And it looked a little suspicious. I'm not going to lie. So, but then we got evidence that proved that none of it could be true. But the point is if so many of us very intelligent people were duped in the beginning, you can imagine how many more people have been duped this entirety of this time. And they're at this point just grasping to hold on. And I just feel bad for some of them, knowing that, like, in the end, everything's going to come out, especially when it comes to his trial. All of the things that he did to get to this point and to lie to these people are going to come out, and everyone's going to see it. And they're going to feel terrible. Like, some of these people are I've gotten messages from people who are like, I'm ashamed of myself.
Yeah. Oh, they're back.
Yep.
The mafioso boss is back in her chair.
Right? With the stack of papers.
Someone needs to make like a Don Karen.
Right. Dawn Karen and her Tito's. Look at her face, dude. She clenches so hard on her cheeks, like bites the inside of her cheeks. Like,
yeah, because she's very concerned about her looks.
Right. Good morning, Kim. Like, I mean, it's absurd. Like, dude, it's just resting duck face is what's happening.
What the hell is Yannetti even doing there? Like, I feel like he's just.
I feel like he hasn't done anything, right? Like, he just kind of looks lost in there. Like.
And is it true that he basically got his questions from the DUI lawyer when he asked that guy about like old levels and stuff like that?
Good morning, Eva. Yeah, I don't like it's crazy to me. Like, why is, like, I know it's his license, so that's why partly, he's there. But I feel like throughout this trial, he has literally looked like off into the distance, like he's lost and just doesn't even want to be there anymore. Like,
I mean, to be fair, I wouldn't want to be there anymore either.
True, I wouldn't either, Dilly. I don't know anything about.
Like he's sitting right next to the victim's mother, and hears her cry constantly. I mean, it's kind of like a hell to be in, to literally sit right next to the victim's family while they're crying.
Mm-hmm.
You know what I mean? Like, I could not imagine having to sit through that day in and day out during a trial and listen to the mother of the victim cry and the family and all this stuff. And then sitting next to Karen Reed, who's the most unemotional person I have ever seen in a murder trial.
Absolutely. I can tell you this, Dilly. I can tell you that they're not going to find communication because Peter has never spoken to Hank Brennan. And he, as far as we know, Cosgrove at all either. So they've both said so. So there's no communication they're going to find. When Kate said that she was cooperating, she meant when people send her information, just like when they do to me, guess where I send it? To the state police, where it belongs. The state police is also the Commonwealth. You realize that, right?
And to be fair, Kate's been through a lot of harassment. And I don't, you know what I mean? They've gone after her kids. They've gone out, you know what I mean? And I don't agree with that type of shit.
Yeah, no.
You might disagree with her in the theory of the case.
You don't even have to like her, but like that kind of stuff's, it's unacceptable.
It's really unacceptable. Just like if I saw people like harassing Turtle Boy in real life and attacking his kids, I'd probably be like, whoa, that's kind of fucked up, man. You can't do that.
His kids haven't done anything other than be kids,
Yeah,
like,
you know what I mean? Like, I could dislike Turtle Boy, but I could say, like, his real life is off limits. You know what I mean?
Well, I mean,
the authorities handle out.
Dumpster fire anyway, but like his children should always be off limits. Children should be off limits to anyone. They're children.
Like when JLR went to his house, like his neighborhood, he was filming in the front. Turtle Boy did not like that. And, instead of getting that perspective of saying like, man, I should not be doing this to people.
Yep. He didn't
double down. He doubled down.
And then called the cops for help, by the way.
Called the cops, the corrupt cops for help.
The corrupt cops to come help him to the person with their First Amendment right outside on the public sidewalk. And so I love the grift of it all is right there.
Speaking of JLR is like a troll. I'm going to tell the free Karen Reed people. You're arguing with the master troll. He does not give a fuck about you trolling him. He enjoys it. He has literally done, I think, 4,400 lawsuits to troll the judicial system. He's in the.
Didn't they like say he can't file anymore or something like that?
He has to file an actual good lawsuit. He can't just sue the Statue of Liberty anymore. But he is the ultimate troll. And it's like, it's funny that people are trying to fight with him on Twitter. And I'm like, guys, you're fighting like the grand master of trolling. It's like, there's no point in that. He will troll.
Right.
That's why, like, I felt like if Aiden actually went after JLR, it would be the biggest mistake in his entire life, because you're dealing with someone who knows how to proceed litigation, knows how to fucking really fuck with you beyond what you can imagine. Like, the guy knows what he's doing. Like, Aiden is an amateur in comparison to what JLR can do. I follow JLR. Like, he's like a level of like crazy that I would probably not want to fuck with, to be honest with you. And and I it was kind of like when I saw them both like in that same kind of area fighting, I was like thinking like Godzilla versus King Kong type of deal.
Godzilla versus, yeah, exactly.
Let them fight. Let them fight. I also said, I'm like, Aiden's gonna learn the hard way. You don't fuck with JLR. Like, he is not someone. He is definitely someone you got to be careful of. He is really, really someone you have to be careful of. He's sneaky.
Right.
He's not stupid like fucking Kearney, where he's like up front. He'll go.
Jurors. Just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct. All right, thank you.
Resting duck face. Yeah, that's what I call it. Resting duck face, because that's what she looks like. Like, here comes the jury. He is riding out the end of his license, I believe.
I think if I was like the family, I would think about trying to sue these people, like the lawyers. I would try to figure out how to do it, to be honest with you, because I want to go for the root of the cause. And these people are the roots for like releasing grand jury minutes and all that stuff. I'd even try. What is that buzzing sound?
I don't know. I have no idea. You know, the court also doesn't seem to realize that, like, especially with the lawyers, when they get up there and they're asking questions and they're ruffling papers while they're playing a clip, like, we can hear all the ruffling of the papers. Like,
I would try to go.
Hear ye. All persons having anything to do before the
hear.
Beverly Cannoli, the Justice of the Superior Court, hold an indebted.
Yeah, I would try to sue Alan Jackson, Yannetti. I would try to sue those people, to be honest with you, because they have money.
Oh, absolutely. 100%.
Please be seated.
Oh, yeah. I forgot.
And the FBI. And the FBI.
I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing?
Anyway, I'll see you. I'll be in the chat.
Absolutely. Thank you, Tim.
No problem.
Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
What kind of link? What do you mean?
Affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
Daniel has he's in the Discord. I have communication with him.
Mr. Brennan, your next witness, please.
Thank you,
He
Your
is an
Honor.
alleged
Commonwealth
victim.
calls Connor Keith.
He has contacted the PD in the area. I don't think VTIM has a link. Kind of just pops in on other channels. He's just a panel guest, but we have him here anytime. He knows he's more than welcome. Good morning, sir. Follow me. Morning, Joan. Good morning, everybody. While we were talking, that was saying good morning.
You raise your right hand. You solemnly swear the evidence given to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Good morning.
Good morning, Your Honor.
Thank you, Arlene.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good
$25
morning.
Amazon
Good
gift
morning,
card.
sir. Could
Appreciate
you
you,
please
Arlene.
introduce
Thank you.
yourself to the jury? Spell your last name for the record.
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's office.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police SERT team, the Special Emergency Response Team.
Are you part of the SERT team?
I am not.
Did you see what the SERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The SERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
Okay.
Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes,
Do you write on the outside of the bag?
yes,
Why do you do that?
to memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Thank you. Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Dean Eddy?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes,
Would you ever write a time later than when the item was found?
yes,
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
yes,
Is that one of the items you bagged that night?
yes,
And if we could turn to 76A, please. Do you recognize that item?
yes,
Is that an item that you bagged that night?
yes,
Do you have both of those items with you?
yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay. Thank you very much.
Okay.
Sorry, I'm muted. I didn't know. Thank you, Freak. I was muted. Of course, we had a sidebar. Thank you, Arlene, for sending a $25 gift card to Amazon. That was our first donation
So,
of the
Mr.
day.
Brennan, I leave it to you and the witness how you do that part.
Yes.
I appreciate it, Arlene, so much. If anybody else wants to donate to the channel, it's super
Sir, in the
helpful.
small chip piece,
We
you
can use
don't
the
know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
No, Eva, because she hasn't been in jail, so she doesn't get any time served.
So we're
None
going
at
to
all.
mark the little chip.
You
Ms.
would like to mark
Giannetti
it?
asked to
Okay.
mark that.
You don't get any time
Then we're
served
gonna
if you're not
submit that
actually in
right
jail.
The small
So
chip.
no.
that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Mama Bree likes Buchanan. He's we call him Trooper. God bless the USA.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Ah, there it is.
Could I
Figured
have
you-
exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I want to pick Hank's brain so badly. I'm definitely going to try to get an interview after this case is over.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The
Yep.
piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
There's no objection, Mr. Giannetti?
There's no objection, no.
Exhibit 79.
For
I'm
the
gonna
court's
eat my
permission, could we show Exhibit 79 to the jury?
Yes.
I'll just be here stuffing my face, eating breakfast.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keith, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet.
No,
The lead investigator is the trooper who is responsible for the case, correct?
yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
you'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
okay.
He had a whole line of questioning about that. Now he doesn't know what to ask.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes,
Okay. If you saw a copy of that report, would that refresh your memory?
to an extent.
May I approach, Your Honor?
Yes.
No, not at all.
Yeah. I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done. And Trooper Keith, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
He was trying to get him not to read the entire thing. Shocker. If I was him, I would want to read the entire thing to refresh as well. Like, because you're going to try to mislead me or say something I didn't say or take it out of context. So I want to read it. Thank you. These people that believe the sewer turtle when he says shit like that, a nod is just a baseball signal to them. Like, I'm sorry, but you have to be a very unintelligent
Having
person.
reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. May I approach, Judge?
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes,
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
She should be pro se at this point.
Sorry.
Why have attorneys? Just why at this point?
And again, if you read that silently to yourself and look up at me when you're done.
I don't know. Maybe the end, Joan. I'm not really sure. It doesn't make the defense look good. Once again, you're trying to go after a trooper. You know, change top chat. If you're on top chat, change it to all. When you come on YouTube and you're on a chat, it's automatically on top chat. So go to the top and change your setting from top chat to all so you can see every comment. Otherwise, you'll miss comments that YouTube doesn't think are top comments. Conspiracy dog poop? You know, the papers drive me nuts because we can hear everything.
Having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video.
Right.
I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes. Again, I only got a copy of the surveillance video.
Sure.
I did not do any analysis.
And with regard to the waterfall bar and grill,
Objection.
that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Yeah, the other day he had that rant
Now,
that said they're dead to him.
Another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
No. Look at his face. He's like, approach over a nickname? Approach over a nickname. Like, I've never seen such ridiculousness in my life. Usually, even if there's an objection, like, they argue it right there on relevance and the judge says yes or no. The sidebar thing every 5 minutes is getting real freaking old. Real freaking old. Ashley points out a good point. There's actually 196 of you total watching between X and YouTube. If you're over on X, come on over to YouTube. We have a great live chat. I think you guys would enjoy it. Also, hit that like button, hit the subscribe button. If you can donate to the channel, it would be very, very helpful. We could use the help for sure. The longer days are sort of killing us over here. We have Cash App, Venmo, PayPal, Revolut for you around the world. To send and receive money, you can use Revolut. We also have an Apple Pay
Trooper,
link.
in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
Yep.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
I was gonna say,
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John
Thank you,
O'Keefe
Jason.
had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Objection.
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
May we approach?
May we approach? Okay, we have a longer version, guys, of our sidebar clip. We can thank Freak. I feel like that's what our whole day looks like, yeah? Like, that's what our whole day looks like, right? constant sidebars. Sidebar, 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 sidebar. I asked and I shall receive. Thank you, Freak, for making me a longer version. Oh, yes, that is the extended version. The extended version. That's what it looks like. That's what our whole day looks like, you guys. Just, back and forth, back and forth, back and forth. Like, sidebar, 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 sidebar. Like, oh, it's obnoxious. Also, I didn't get a proper thank you to Arlene because every time I try to say thank you to Arlene, I get cut off by them coming back. So I'm going to do it real quick. Thank you, Arlene, for the $25 gift card that you sent to Amazon. I appreciate you very, very much. And she sent a comment that was really funny. And she said, Karen Reed is guilty and Turtle Boy's an ass. So thank you, Arlene. I appreciate it very, very much. We can always use the help. That's our first donation of the day. So thank you. Hey, Jack. Yuckity yuck. Don't talk back. That's the thing. She said no one time and then took it right back when Alan Jackson was like, but Your Honor, we need to approach. I know, right? 45 seconds.
Were you watching Dr. Scortibello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing. Just ask me.
What direction were her eyes facing when she was examining John O'Keefe's body?
What?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank you.
Wasn't staring at her eyeballs.
Looking at the body, you saw her looking at the body, correct?
That's a weird line of questioning.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
I was going to say I'm not a doctor. Good answer. Not a doctor to tell you that. Objection.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
What?
I've never experienced that.
Right.
Because
and
you don't know.
There was no defense attorney or defense expert at the autopsy of John O'Keefe.
There never
correct?
is.
Not when I was there.
You were there, correct?
Yes.
This is a weird line of
And
questioning.
there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
No.
It's not input.
Okay.
It's not
Did
input.
you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No,
That was a
thank you.
really strange line of questioning. Pretty sure our jury knows that the defense attorneys and the defense experts aren't there for an autopsy.
Jurors, this break we're going to take now.
At 10 o'clock? You're taking a break at 10 o'clock, lady.
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next hour. Maybe.
Wonderful.
I want counsel to stay.
What? Want
All
counsel
right,
to
the court,
stay.
please.
Cool.
Close the notebook, follow me.
Unattended deaths. Oh my God. Is this real life right now? Can somebody explain to me where? I know. Where's Joy? Joy, are you in the bushes? We still have audio, so I'm waiting to see if they actually argue it publicly or like they're going to do it at a freaking sidebar per usual. Like, that's another thing. Judge should be striking comments from the record and telling him to disregard it with an instruction. And I haven't seen her do that in a while. Like, come on, man. It is tiresome. Like, 10 o'clock? At 10 o'clock in the morning. You guys couldn't have got this stuff done after court yesterday while we were out an extra half hour. Come on.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Yep.
Understood, Your Honor. I first want to just get the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's
Okay.
governed by federal, Massachusetts Rule 39A. And that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
Exhibit CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, and the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor.
She's not going to prohibit
I am
anything.
not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable.
No.
And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas.
He's going to lose this.
It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes,
Thank
right?
you.
Exactly, Your Honor.
What is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know
No.
exactly what you're asking
If I could
me
proceed
to allow.
and give you the answer, Your Honor, I
Go
will
ahead.
explain it. It's a very short answer.
Okay,
What I want to do is with regard to her
Not gonna let him, it doesn't
227
matter.
timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple's source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on
He's
the
an idiot.
topic, using this decision to say, in Maryland, you tried to do the same thing with
This is
regard
mess.
to FLH. You tried to use a surrogate approach and make an opinion about
That's how they
whether that is in
Idiots.
fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her
Nobody has that
reliability
source code.
for the conclusions I anticipate she's going to make on 227.
so if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do
Oh.
you say, Mr. Brennan?
This
It's
is an
absurd.
attempt to try to malign a witness with something that's
Yep.
wholly unrelated and not relevant to what she's going to testify to or
Yep.
the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location.
I'll
That's
explain it.
not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. It's here. Number one, what he said, I really can't follow him. I don't understand, other than
Because
he's
he's not
trying
making
to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
Nope.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it
Nope.
was. The 227 timestamp would.
No, that was raised, but this
No, which means it's not going to happen.
problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor.
Okay,
What?
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That
It isn't.
doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I
He's an
could,
idiot.
Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their
This
methodology.
doesn't go to her
And
reliability
with regard to the
or
Apple source
methodology.
code, if Your Honor would please turn to page 6, the last paragraph.
No.
It says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the
Apple's.
expert did not have access. That's exactly
No
the situation
expert
here and
has
what I want to
access.
cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code for methodology in
Every
the Herrera
expert
case
does.
she got advertised on because it wasn't reliable.
In
That's
Maryland.
exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
Nonsense. All
You
nonsense.
can see the plan to dehumanize somebody, daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just
Or reality.
dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if a expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court.
Every
Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology.
Correct.
And they presented that. They proffered that evidence as reliable. No
They
different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the
He knows
first
he's
trial,
losing.
the first trial, this is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There
Bullshit.
is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation.
No.
I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's going to, that's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that.
No, you're
We
not.
can't be saddled, it's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk
Oh,
about
of
in
course.
this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point
your
is,
opinion
Your
on this.
Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term downwardized anymore. She's been deemed unreliable. Attorneys
No.
who do experts all the time, that's the verb
Nope.
you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to
Yes,
do is to impeach her on her reliability. So in conclusion, Your Honor, the
This is
Herrera
the
case,
weakest
she was
argument
deemed
I've ever
not
heard.
reliable.
No, she was
That's
not.
competency.
No.
You,
Looking a
and
little
any
looking at him
expert
like,
that's been deemed that
try.
you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand.
No.
Let Mr. Brennan make that point on
They
redirect.
don't need
But
to.
I can't have my client's constitutional right to confront her on the very subject matter
No,
she's going to
please.
testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness,
No, it's not.
particularly when their methodology on
This
data
is you
forensics
trying to
has
play
been deemed
games
not
with
reliable by a court. And one part is the location she has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable.
Nope.
It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible.
Nope.
Unless they were talking about the very same methodology and the very same point.
Correct.
This has nothing to do with her opinion whatsoever.
Nope.
It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a
Correct.
different judge and distorting the fact that it's two different methodologies, it's two different issues.
Two different case in a different state.
One last word. Go ahead.
Thank you, Your Honor. You just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's
Your
a red
methodology
herring
has nothing to
bring
do
up
with it.
credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant.
It is.
Court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't,
It's not.
it shall be in evidence.
Nothing to do with
So
it.
there's two issues here.
No.
And I think the Commonwealth is conflating that. The question first.
The Commonwealth
is
is conflating?
this admissible? Can it come to evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final
wasn't.
sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this
not
opinion.
the
It's
point.
all about this hot. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly
I don't
what
think
was
she lets
issued
them
here.
do it.
The 227 timestamp, she has no, in this.
They already have done
further
English.
across,
I don't think she lets it
has
happen.
no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she
What?
had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear
It's like putting
that
two
it's a
things back
proper
into
basis
struck or
for
not, no.
cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
No.
Your answer, Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for
Yep.
the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is
Exactly.
in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would. but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point. in the
Bingo.
case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensic
Oh.
expert we're going to call, but if I
Of
could, just
course.
10 seconds,
Okay, but then answer my question after your 10 seconds.
but I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology
Stop
and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an
Oh my
expert.
God, this
Her
is torturous.
competence has been determined in this decision. And it
I wanna
is
punch
her,
something.
because it was her
He makes me want to
report
punch things.
that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense.
It's not handcuffing the defense.
Now to answer your question.
You
Your
have
Honor,
handcuffed the Commonwealth.
we are going to have a witness that is going
A
to address the 227.
That's not answering the
Whether it's Mr. Green or somebody else, we haven't determined.
There's the answer.
My
It's not
point
gonna be
on that,
Green.
Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's,
Yeah. And Your Honor,
No,
my point
he
would
knows
be
what they're
that's
doing now.
obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right respectfully to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort
What?
of having a pre-authorization of
That's absurd.
rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness
Oh,
on an
please.
issue they're raising. I'm not
So-
raising it.
you can
You are
see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask what you may I, Mr. Craig?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Absurd. This is absurdity. What he just argued was basically that a Maryland court found that because experts don't have the source code to Apple, no expert has the source code to Apple, only Apple has the source code to Apple, that their methodology, which they're not using that word, but the way that they got to the answer on a specific thing that they were arguing in that court, which had nothing to do with a 2:27 a.m. timestamp in a suspended state, like in this case, but they're arguing that because she doesn't have the Apple source code that the experts in Maryland, not Massachusetts, Maryland, that it wouldn't be like basically correct to bring it forth. Like this is not Maryland. This is Massachusetts, and it's not even the same issue. Number one, which is Hank's point. Number two, all they want to do is be able to be like, hey, so another court found your thing to be unreliable, so therefore you're uncredible. That's all they want to do, even though it's not her opinion specifically. It's any expert that doesn't have the Apple source code was the point of the case. No expert has Apple source code. Apple is the only one who has Apple source code. As the judge, which I'm surprised she knew that, but as the judge pointed out, like, this has nothing to do with what they're trying to argue. She should absolutely not give them this. It should be denied outright. It is trial by ambush. Jessica Hyde is there today. So clearly we were going to hear or are going to hear from Jessica Hyde today.
Hey there, Karen Reed trial watchers. You know what a lot...
I can't stand that guy's voice. I'm sorry. I had to mute it. They're arguing apples and oranges just so they can say, because they don't like that Jessica Hyde is going to prove once again, just as Ian Whiffen did, that it's nonsense. And this was the judge's point, is Mr. Whiffen wasn't talked about on this. And why did you wait until today to give it to me? Why? Because it's a trial by ambush per usual. You know, they had this information long before now. They didn't just pull it out of their behinds, which is why when the judge asked, he said, I have no good answer for that, Your Honor. Of course you don't. Of course you do not. Ooh, well, you did because they went on a break. That's why. It's Zoom. So they went on a break. That's why you got booted. I'm like enraged right now. I'm sorry, but like my blood pressure just went through the roof that he even attempted that argument, which meant literally nothing. Like that just really, like, bro, you just argued two completely different things, tried to conflate those issues together and misrepresent what it was to the court. Like, it is desperation, Joy, 100%. Like, I can't. I literally can't. I love that you came in, Joy. We were literally just asking for you, by the way. Wanted to know where you was at. Where was Joy? Sorry, I'm just scrolling up in the comments for 1 second. Boop, 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 boop. Oh, yeah. During the nonsense that happened, Agent 99 sends a $5 donation. Thank you so much, Agent 99. I appreciate you, my friend. And I'm touched that you trust me with your information. I will say again, though, my Venmo is locked. Nobody can see it but me and the sender. That's it. So nobody can see my friends list. They can't see the name of anyone. They can't see transactions. It is completely locked down. So no one can see anything. So don't you worry. And I would never, ever give out anybody's information. Let's just make that abundantly clear. I just want everybody to know that would never be an option ever. But thank you, Agent 99. I appreciate your $5 donation. If anybody else wants to make a donation to the channel, we certainly could use it. We are 2 hours and 5 minutes into this probably 8-hour stream, I'm guessing. We have options like Cash App, Venmo, PayPal. We have Revolut for those of you who are not in the country and all around the world. It works for all sorts of countries to send and receive money. We got our first Revolut the other day from Trisha. I appreciate you, Trisha. It was exciting to get my first Revolut, to be honest, and exchange it. We also have an Apple Pay link, and there's also the option of e-gift cards, which people send sometimes to anywhere, really. We got our very first donation this morning from Arlene, who sent a $25 Amazon gift card. Thank you, Arlene. If you are trying to get in touch with me, you can always do that. twistedtragedies3@gmail.com. That is always an option as well. Apple Pay. We have an Apple Pay link. What is it Apple Pay making you do? Let's see. Joy said, yeah, and she already testified exactly as an expert witness. Like, already. Like, that's the part that gets me. Like, Joy said, I love the extended clown song and clips. Erin O'Keefe's expression says it all. It does. She's sick of those. Defense is scared of this witness, of course, because Karen's defense is unethical. Yeah, I agree. The judge gets me, bro. I mean, like, I don't see how there's any way that she allows the defense to do this. Honestly, it's clearly by ambush. They had this information for a while. B, the two issues are not even the same, and it's a different court in a different state. It's not even the same state. Like, and again, not the same issue. It'd be one thing if it was the same issue. It is not the same issue. And it wasn't just about Jessica Hyde. So them trying to like conflate that, it was about any expert who doesn't have the Apple source code. Like no expert has the Apple source code. Only Apple has the Apple source code. Like, you know what I'm saying? Like, it won't. That's weird. Is like Cash App down or something? Is that like a thing? Is it down? Sometimes we have those like outages. Like I heard Zelle was down. I don't have Zelle. You can only go through your bank now. My bank doesn't do it. But I heard Zelle was down for like almost 2 whole days the other day. It was weird. Oh, I see a Cash App. I see it, Willow. I see it. Willow sent $6. Thank you, Willow. I appreciate you, my friend. Put a little heart next to it. To put a little heart next to it after I see them that way. Or after I try to every time, although clearly I failed yesterday in not doing a heart next to everyone. I send a little heart back to know that I got to that one. Let's see. So I find, to me, this is just amazing that like they brought this as an issue. Like, this is not an issue. Like, yes, it's working, Ash. Thank you. It is working. Ashley sent a buck to see if it works. It's working. Thank you. Sometimes there's outages, you know? Like one day I couldn't use my Venmo card all day long. There was like an outage. And it just was like declining at the store. And I was like, had to look it up. And it told us that there was like an outage. And I was like, well, that's BS. Right? Your Honor, it's devastating to our case. Please do not let anybody read it. Like, that's essentially what they're arguing. Like, most of the time with the bull is like, hey, well, what we know this expert is going to say is going to be very damaging to our case. So we're going to need you to like not do it. Like, we're going to need to try to, you know, impeach the witness. The problem with that is Jessica Hyde's not the only one who has said this. Okay. Ian Whiffen has as well. So that's the problem. Like, they can't keep using the same argument. I don't think she can, especially here's the problem that I have, right? Is the defense has already got an upper hand here by ambush, especially with the ARCA stuff and waiting. Sorry, I lost my train of thought for a second. Oh, on waiting on the ARCA report. So they got the ARCA report, should have been in today. Today's the 7th. So it should have been in today. So they're already at an advantage of this ambush thing that they like to do. So I don't see how the judge can allow them to sort of ambush again, have another upper hand that can't be rectified. Not that it's really even an upper hand, but it's a way to try to say you're discrediting a witness by misleading the jury. That's the problem that I have, is the judge can't allow them to mislead a jury by saying like, this expert's way of getting to information is wrong. It would have to be that every expert who doesn't have Apple source code, it would have to be mentioned like that. It can't just be this expert, because then you're misleading that this expert alone's opinion is not good for some reason. And that's not the case, because the court was saying like, you know, Apple source code, if they don't have it, like, then they can't. Nobody has Apple source code. I'll look at the text in a minute, Ash. It is an ambush. It's absurd. They had this information before. They did it last minute on purpose when they knew Jessica Hyde would be there. I'm sorry, but I just don't see how the judge could allow them to sit there and do what they just did, because what they just said wasn't actually what was in the case. There's no issue around a suspended Safari tab for 2:27 a.m. That's not the issue that was raised in that case. Like, it is not even close to the same at all. Like, that's the other thing. We're not allowed to even talk about how Mr. McNasty, lied to the cops. And guess what? It's sounding like they're not even going to call Richard Green, because when the judge just asked, okay, when the judge just asked, are you going to call Richard Green? Their answer was, we're going to call someone. We're going to call a expert, which means they're not intending on calling Green at all. Or their answer would have been, yes, they're not intending on calling him because they know he can be impeached and it would be very bad for them. So they're not going to intend on calling him. They're going to call their other expert that they have, not him. So, I mean, this is just their way of like knowing that Richard Green was going to be impeached and look like a fool. So this time they want to try to sort of reverse that table. But the problem is the judge can't just allow them to say things that aren't true or question things in a way that are not true blatantly when she knows that's clearly what they're trying to do. She's going to go back into her chambers. She's going to read what she has. She's going to read the case, and she's going to realize these are not the same things. 1 and 1 over here do not go together, okay, because they're not the same. So then she has to decide what she's going to say to them, like what she's going to tell the defense. Like, hey, you misrepresented again. Or, hey, sorry, not sorry, but this is not something you're going to be able to question on. Like, if Jessica Hyde is already there today, that means we're probably going to hear from her today, and now it's probably going to be pushed till tomorrow. Like, I'm sorry, but the judge, any judge, should be able to answer something, half hour or not. Like, this is what judges do. I need more time. Well, Your Honor, you don't have more time. And because they brought it last minute like this, it should have been rejected outright. But the fact that she isn't, cool, look at it, fine. But you shouldn't really need more than a half an hour to read the case itself and then realize like what they're asking for isn't even close to what the actual case with Herrera was. Like, oh, thank you, Willow. I appreciate you, my friend. I appreciate that. I do. I try the best that I can, that's for sure. I think they had 2 like digital experts listed because they knew Green was going to be a problem. It was a ridiculous argument, in my opinion. Like, Freak said, I have no doubt the defense cannot get another digital forensic person to corroborate the 2:27 a.m. nonsense. No, I don't think that they can. I don't think that they can. But it sounded like they were not trying to call Green. So are you guys not even going to try to say that that happened? Or are you just going to try to cross the Commonwealth experts to say it didn't happen and never call Green? Like, as far as I know, they had one other expert that was like digital wise. Like, yeah, but they can't ask for a new expert during trial. So Green would be it. If that's the only one they got, that's who they have to go with. If that's why when he said we're calling a expert, it's like, okay, well, what expert? Because you can't just get another expert during trial. It has to be done pre-trial. So waiting for the judge to go read her thing in her chambers. Like, I know it's always something. It's always some sort of holdup. So yesterday when she said, oh, well, we're ahead of schedule, we'll leave a little early, it was 3:30. And in my mind, and I said it to you guys, it's like, why not deal with other issues that you have while you have a little more than a half an hour? Because as we know, these holdups are going to keep happening when it comes to the defense because they keep dragging and dragging and dragging. Like, I agree with Jack. They are upset the Commonwealth is trying to make Karen look bad at her own murder trial. It's kind of how it works, you know? Like, no, they're not gonna, they can't find one now. Even if they did find another one right now, they're not going to be able to get a report and do all that stuff in the middle of trial. So they'd be stuck with who they have. But I could have sworn there was one other digital expert that they had. They do know that it's debunked and they do know that it foils the conspiracy. So they're trying to find another way around it, another way to say that it happened without putting Richard Green on the stand to be eviscerated by Hank. Like, it is an ambush. That is what it is. But in my opinion, the judge should have said, I can't do anything with this. This is during trial. There's nothing that I could do. Once he said, I'm not trying to exclude her testimony, that should have been the end of that. Okay, well, then there's nothing I can help you with. This case is not even the same. The Herrera case is not even dealing with the same issue. Not by a long shot. Like, she is going to F up, just like Hank said. You can't, you're trying to like let in case law that says no expert has a reliable opinion if they don't have Apple source code. No expert has Apple source code. The only people who have Apple source code is Apple themselves. Like, I agree with you, Insider Man. I don't see how she could move forward with it, like in a legal standpoint at all. Like, there could be, there might be at McNasty's. At McNasty's, you know, like, that's so nice, Jesse.
Hey there, Karen Reed,
Oh,
trial watchers.
you shut your face. You shut your pie hole, guy. We don't want to hear you. Like, oh yeah, it was totally fine for that. It was totally fine for that. You know, B. Harley. That's cool if the defense just keeps lying, just and misleading. I don't know how like she at this point hasn't screamed at them in open court, because any other judge would have. Like, I mean, here's the thing. Even if they do allow it, let's be honest here. Hank's going to do his job. Jessica Hyde's going to do her job. They're going to look like utter fools anyway. Even if you question her on it, she was in that court case. So like, she's going to tell you what happened. Like, so, it's not going to look good on the defense one way or another, even if she does allow it. I just don't think she can, from a legal standpoint, in the middle of a trial on the day or day before this person is going to testify. We're going to have to hear from her before Friday. Hank said she's got to leave. Cannot be here Friday. So, aww, puppies. Not that they're all puppies, they're dogs, but still. Dogs are loyal as F, you know? She might. I like the color pink, though. I refuse to let Karen ruin pink for me. I like things that are pink, things that sparkle. And I also like skulls. I love Halloween. So I like, they have like a skull that has like, little bling pieces on it, or one that's like a pink sugar skull, or even the ones that are like my rugs in the kitchen have like black and white skulls on they're cool. They're very cool looking. They look like Halloween-y, but not necessarily have to be used for Halloween. There's no orange in them. It's just black and white. It's very cool. Service animal, my daughter has service dogs. My therapist says I should probably get one, but a dog is a whole other responsibility. They definitely make you feel safe, though. That's for sure. I feel like Alessi should go back to like watching Matlock and knitting a sweater. I'm just saying, like, you should go back to watching Matlock and knitting sweaters or something. I feel like, that's what he should be doing. His like long-winded talk about nothingness is what gets me. Like, you're not even talking about the same thing. And your legal argument to this is the most ridiculous. He has made the most reaching, silly straw-ish legal arguments I have ever heard a day in my life. Like, no, Green is their digital forensics expert guy that tried to say 2:27 a.m. happened. He called Ian Whiffen, and Ian Whiffen called him back, and then he never called Ian Whiffen back. He called Celebrite to figure out how to read it, and then incorrectly read it as if 2:27 a.m. was the time of a Google search when it was not. So he is the one that started all of this nonsense with the Google search, and then apologized on the stand last year when he testified if he caused any harm. He caused more than just harm, okay? Like, yeah, and that's exactly the kicker, Deb, is it 2:27 has nothing to do with proving her guilt. There's plenty of pieces of evidence to prove that. Like, the defendant has a right to cross, but they don't have a right to cross on something that is in a case that has nothing to do with the same thing. You cannot cross an expert witness on something that has nothing to do with the actual issue. The issue they brought in Herrera is not the same issue. So they're trying to use a completely different issue to raise a concern about the expert's credibility. That's not, I've never seen anything like that happen before. And then what you would be doing as a judge is opening a legal precedent that any expert who doesn't get Apple source code, which is going to be every expert in the country, certainly any expert that testifies in mass, they can be questioned on their credibility. That's absurdity. Like, I mean, I don't know. I know they have a couple people that they expect to drag up there. I don't think it's going to go well for them. I think ARCA is going to be an absolute joke for them. I mean, they still have Russell on their thing. I don't know why you would ever call Marie Russell unless that's why you brought in Garrett Wang. So you could replace Marie Russell because she's a friggin', I mean, it's a comedy. It's a circus. Like she's a comedy show on the stand. I'm the only expert in the entire country that can tell you all of this. It's hilarious to me. Like you're an ER doctor that retired like a freaking decade or more ago, lady. Like you're the only expert in the world, in the country. Nobody's more qualified than you. Like that is the most egotistical. No wonder why she read the article on the Boston Globe and reached out to the DA's office in LA. She clearly wanted to be a part of this. You can tell by her answers. Like, oof, I worked nights for a very long time. I would not work them again. Not at this age, in my late 30s. Joy said exactly. We can't find a single witness that will say Jen called at 2:27 a.m. or Googled. So their strategy is to run their mouths off about it in public and try desperation tactics to keep out the Commonwealth's evidence. That's exactly what they're doing. If she allows it, it is a kangaroo court. I don't understand how she could, to be honest. Well, she has said that the entire week is supposed to be full days, but you never know. She might do that for some unknown BS reason. Like, I also appreciate Hank's Barb about accident reconstructionist testifying to medical opinions. Great way to perfectly slim the wool in experts' clothing. That's true. Yep. It's not relevant as the methodology is different in each case. So that's exactly right. They're getting to the answer in a different way, and it's also not the same issue. Like, well, they do, but the jury wasn't in there right now. But I do think that they brought Alessi in like on purpose. Like, but like, did you guys bring them there to confuse the jury? Because that's not going to help the defense case, because the defense needs to put on a good case too, even with Cross. And they're not. When you have Alessi crossing, nobody can follow him. Not even the goddamn experts. Not even the credentialed experts can follow what he's saying. As the words of the guy that's the meteorologist yesterday, I don't understand anything in that sentence. That's what he said to Alessi. Nobody did. Like, what are you talking about? And that's exactly it. They were stuck with Russell because no one else in the world would say that they were dog fights. They clearly are not. Like, well, that's exactly Brennan's point, Eva. It's a trial by ambush once again. And it was brought to the judge right now, right this minute. Like, that's suspicious on itself. Like, oh my God, me too. For literal, like, I feel like, I kid you not, this is like, this is torture, literal torture, having to listen to that man. Okay. It's cruel and unusual punishment. And I feel like we should sue the court for having to listen to him. All right. Not that that can actually happen, but like, if it could, I would do it. Like, she is an embarrassment to the medical community. You could definitely say that again. Like, this year they also have, Mr. Wing, which I think, once again, how did he get this case? Oh, that's right. Following it on YouTube and then making his thing mold to fit the conspiracy because he wanted a piece of the 5-minute conspiracy pie. How dare I know? How dare I, right? How dare I not be an idiot? But apparently that's what the cult says. I'm so dumb. I have no idea what I'm talking about. None at all. None. You know what it is, Cookie, is that case, the Herrera case, that case was from like February, maybe April-ish, March, April, somewhere there, February, March, April, somewhere around there, that that issue was in that case. And I didn't realize Jessica Hyde was the expert, because I just skimmed it. There's lots like cases that I read. There's like a whole log of them for like issues that are decided on certain cases. And I'm a reader. That's what I do, especially when it comes to law stuff. So I'll read up on like the newest cases in any state that are like interesting enough to read. In that one, I skimmed the Herrera case, and the issue was not even the same digitally. Like, we're not talking about a Safari suspended tab in suspended state tab. We're not talking about a DB wall file in the Herrera case. Like, just say that what anybody who doesn't have Apple source code is not credible. That's absurd. Nobody has Apple source code except Apple. Like, you know what I'm saying? Like, the only people who have that are Apple. So that would set a ridiculous legal precedent that no one wants. I don't see how this judge could want that. That's for damn sure. Like, they keep pulling these BS tactics over and over because you keep letting them get away with it. Exactly. It is like bratty children who are never disciplined, so they always are bratty. Like, she should have, right? In my opinion, if I would have stopped him immediately to be like, this is during trial, Mr. Alessi. Like, these two cases are not even the same. Even if she skimmed it, she would know that. So come on now. My gut is screaming at me that she's going to give them this and maybe sternly worded warning she'll never back up. If she does, she's setting a ridiculous legal precedent, but I do think Hank, no matter what she decides, is going to push over it anyway. So it doesn't really matter whether they give him this or not. I feel like he's going to make an ass out of himself. Jessica Hyde is a very well put together, well credentialed woman who's, just backing up basically what Ian Whiffen already testified to. So you want to make her not credible. The defense wants to make her not credible, but she's going to say the same thing another expert already said. So that's not going to be not credible in the eyes of a jury. Sorry, not sorry. And nobody follows a goddamn word unless he says so. Apparently he's the one crossing. Why do they keep allowing him to cross the technical experts when it's very clear that he has no idea what he's even talking about? So he doesn't even know the correct questions to ask. Like, don't ask a question if you don't know the answer. And I keep seeing the defense ask questions that they don't know the answer to. That's lawyering 101, dude. Don't ask the question if you don't have an idea about what the answer is going to be. Like, come on, man. Like, I don't know if I make the most sense, but I try to like break down like the legal stuff in a way that a toddler could understand. You know what I mean? Like, I also have a lot of knowledge in the legal field. Like, you know what I'm saying? Like, I might not be a lawyer, but I damn well have the knowledge of one. Like, doggies are like having babies. That's for sure. So don't have a baby and then get a puppy at the same time. Been there, done that. It's very difficult. Like, if the defense had an expert waiting to testify and Hank brought up an issue, she would immediately knock it down. Oh, she would 100%. She'd be like, sorry, Mr. Brennan, this is during trial. We're not going to do this. And then it would have been done. End of story. Like, oh yeah, did you hear him? Twice during when Hank was talking, he was yelling over him in the background to say something. Like, that is so improper. You wait your turn. You don't yell things while the other side is talking and it's their turn. Like, that is so improper. Like, let's hope so, because I don't understand how it wouldn't make any sense to me legal-wise how she could let this slide, to be honest. Like, yeah, one of the McNasty employees, they're the only ones who could say that. No one is willing to say something they know not to be true. It's their reputation. You know what I mean? The screaming is obnoxious with him. Like, but again, Jackson does it. Alessi does it. But Alessi does that thing where he accentuates all of his words. He stops and says things in this way so they sound important, but then makes everyone tired. That's how he talks. It drives me freaking nutty. Like, bro, nobody heard anything you said because you needed to accentuate every word or every other word in a sentence for no apparent reason whatsoever. That's my point, is the jury probably won't even pick up on it because he's the one doing the cross and he'll make everybody fall asleep. Like, exactly. A fair trial isn't just a fair trial to the defense. It's also a fair trial to both sides. And that hasn't happened thus far. It's to confuse the jury. Like, right? No one is going to ruin it for me. I'm sorry. I won't even let Karen Reed ruin my favorite color pink. She can just F right off. You don't want to hear about Bev's underwear? You sure? Maybe she has dantanas on. You know what we call dantanas? Like Superman wearing like men's underwear that have like, kids underwear, the little boys underwear that have like Superman on it or Spider-Man. They're not boxers, but they're like, and they're not boxer briefed, but they're like, old man underwear. They're called, we call them dantanas here. You know, like when Superman is standing up and he puts his hands on and he goes, dantana, like that's why we call them dantanas. They're called dantanas. I can just imagine Alessi in the mirror and his dantanas practicing. I don't agree, Your Honor. I'll answer that in 1 minute, Your Honor. I'll answer that in just a second, Your Honor. Never answers it. I don't know, Willow, whenever time they feel like coming back at this point. I'm not skipping them. I'm going down the line. They're not always in the same order that you guys are in, though, to be fair. They're not always in like the same order as you guys see them in, because I get ones from X2, but I'm not skipping them. I don't skip them unless they're like something that just says like LOL or like you're talking to someone else. Then I'll skip them. Oh my God, it's so funny. My little one calls my little one says to my oldest one, because my oldest one is blind and has all the medical. And so my little will hold her arm and walk with her so that she doesn't bump into anything or whatever. And she says, Sissy, I'm your emotional support human. That's what she says. So funny, so cute. Right? For real. Pink granny panties. Murmuring delete. They've lied in a lot of other cases. I'm disgusted by the entire defense team at this point. Like, the amount of lies coming from them is absurd. They do need to be held to ethical standards, you know? He's so annoying. It's like we need some raid to get rid of these bugs. It's like keeping raid in your pocket, like AK-47s, to get rid of those creatures, aka the defense. It's like they're little annoying bugs flying around. Just keep the raid in your pocket, y'all. Yeah, I'm not holding comments. YouTube holds them, and I don't even know about it. That's the part that pisses me off, is I don't even know about it. It shouldn't take. She should be able to read the case in less than a half an hour and know. You know? Oh, huge dogs. But they also think they're lap dogs, right? They also think they're lap dogs. You brought up, yeah, exactly. It should have been simple as that. You brought it up a half an hour before they're supposed to testify, or the same day. Absolutely not. Like, you know, no granny panties. You guys don't like the granny panties? If you're shadow banned, it wouldn't see some of your comments though, right? Like, yeah, YouTube doesn't like my mouth either. Sometimes they'll block my comments as well. My own, like in my own chat. But at least they tell me. They don't tell me when they do that to you guys. They only tell me when I try to write something, a big red thing comes up that says, YouTube's not accepting your comment. Like, but it doesn't tell me when it does that, like, takes out anybody else's. Yeah, I do think Russell is a publicity-seeking clown. 100%. Yeah, some of them, they don't let me. Like, it has nothing to do. YouTube just does it without even letting me see whether they did anything or not. So I can't. They do it to my own comments too, which aggravates me though. Like, if you're going to do it to mine, you're going to tell me, then at least tell me when you're blocking other people's. Like, you know what I mean? Yeah. Sleep is, you know, mine is back on track now. I never sleep well anyway because of my PTSD, but like, I at least go to sleep, or like nowadays I'm asleep by like 9. I'm tired. Like, you know, I also have a lot of medical. So yeah, the puncture wound in his shirt, the pig DNA. Must be a bone, right? Porky Pig did it. Yeah, without any methodology or peer-reviewed study, which is why I find it so funny the defense argues against other people. Like, dude, your own experts are idiots and don't have any of that. Like, yeah, how convenient, right? And this is why the judge said, I wish I had more time. But what she should have said was, this is a joke. You knew she was coming. You didn't have this till right now? Like, come on. She should have questioned them on it, and she didn't. He just said, I don't have a good answer to that, Your Honor. She should have said, well, I'd like an answer from the rest of your defense team. When did you come upon this information? And why are you just using it right now? She should have asked questions. And she didn't, on purpose. Like, you know, right? Let's do it. I'm in. You know, all of her minions that pay her legal bills can pay all of her, you know, civil cases when they go through. That's what needs to happen. Like, I will tell you that it is like torture. Like, a lot of this is torture that I have to listen to because you guys depend on me to know and to give you the rundown if you weren't here to hear it. Like, so my parents had a Rottweiler growing up. Her name was Roxy. And she was amazing. And she used to growl at anybody she didn't know because she didn't want strangers picking me up, but she was a big baby. March. Yeah, I knew it was like February, March, or April. No, the Herrera case was like February, March, or April. So yeah, if they could have known right after that and didn't bring it now, like, yeah, no. Sorry, not sorry. Like, sorry, not sorry. Dude, I'm telling you, it's like mental anguish. Mental anguish. Oh, I'm like 10 minutes behind in these comments. I got to get down. Let's see. All right, I'm going to skip some of these. I'm sorry, you guys. I got to get down to the bottom here. My ears have also suffered damage, Jennifer. I kid you not. Oh my God. I wish they could. That would be amazing. No, they can't. Not unless they think he's like drunk or something and then they can tell him he's got to leave. But other than that, I don't know. He does scream. I love when people try to say stuff like that. Like, Hank's not afraid of Alessi. Alessi's just annoying. Like, Hank's dealt with the feds. Do you think he's afraid of Alessi, dude? Yeah, no. Not even the meteorologist was afraid of Alessi. So that goes to show you. Like, he's not afraid of anyone, especially not Alessi. Like, yeah, exactly. They project quite a bit. More than I've ever seen in my life. I think a study needs to be done on these people. Like, for real. Especially in cognitive dissociants. Like, No, she would not let the prosecution. This is her morning break, Willow. This is like literally like her extra long morning break. She told the jury it was going to be longer so she could go back in chambers and read this nonsense that the defense gave her and the case itself. Like, yeah, that's another thing. She told them to stop. Of course, we knew they weren't going to. Yeah, Duntanas. Call them Duntanas, Brie. Oh, yes, my daughter has those. I actually have those still, the day of the week undies. Clearly, you have never watched my channel before, Trish. You can't run a channel without spending money. So this is the kind of ignorance that I mean. Like, you also clearly don't realize that I'm friends with some of the people who are witnesses in this case, do you? That's very clear that you don't know that. But why come to a channel to disparage someone? I'm nothing like TB. Sorry to tell you. I don't sit there and disparage people all day long and use 100 sock accounts to do it or use a mob of people to harass other people. You're in the wrong place there, sweetheart. It's called trolls, Willow. We have trolls. Jack sends $14.99 and says, let's enjoy another day. It's a beautiful day. Thank you. No, thank you, Jack. I appreciate you, my friend. I do. I appreciate all you guys that contribute. It really does help out. Make sure I'm not missing anybody here. I know. I'm like so rich. I can just do this for free all the time, right? And yeah, that's not Trisha. It's not Trisha Kelly. It's a different Trish, clearly. That's very clearly because we have a Trisha Kelly and she's amazing. I have to pay for the stream. And if I make something on top of that, then so be it. I don't even make minimum wage per stream when I do these 8+ hour streams. So let's make something abundantly clear here. I have to cover costs that are associated with stream. And if I make something on top of that, yes, this is my job. Like, this is my job. I would expect that any content creator doing this gets paid. When you cross the line is when you're willing to sit here and tell a lie for more and more and more and more and more and more because more money's coming in. You're willing to lie more and more to those people. I'm not willing to do that. Hence why there's only like a handful of us that will say the truth when it comes to this case. But if you want to troll, this is probably not the place you're going to want to do it. Yeah, she definitely rules on appeal, like being afraid. Like, I appreciate you, Anna. Pepper spray. Don't you love that? When they come here just to say it. Yeah, it's not Trisha Kelly. It's a different one. With what? My kids? Or me? I'm old. I'm 38. I'm old. My kids have huge age ranges. Go from 7 to 20. Probably a hit and run. Right? You can fit in right on over there if that's the case. And it's funny because even if they're a person that follows this case and goes to other channels like, you know, Yellow Cottage Tales or Kate's channel, like what people don't seem to understand is I don't have 30,000 followers. I don't have 15,000. I don't have memberships. So like they have those things where they can depend on a check that comes one time a month for YouTube from their memberships, from their merch, from their super chats and super stickers. I have none of that. None of it. So I can't depend on that like to pay for it, unfortunately. And I am not a rich person that I can just pay for it myself. And like everybody has different circumstances. I do not have the same circumstances they do. I'm a much smaller channel than they are. So I love when people point that out, like, oh, Kevin doesn't ask for donations. Kevin has a monetized channel. He doesn't have to. And also maybe his financial is a little bit different than mine. Like his circumstances are different than mine are. I have pepper spray. My husband bought me a pink one. It's in a pink case. It's like this. Goes on your keychain. No, he said it wasn't an appeal case. That's the kicker. It was not one. I can't help it sometimes. I have to, you know. Sometimes the F-bombs just come out, mama. Like, they just come out. Yeah, me too. Like, literally, like, you know, homework, bath time, shower, dinner, bed. Like, you know, answering emails, text messages, DMs. I do my best. I don't get to all of them sometimes, but within 24 hours, you get a response. I'm usually pretty quick. Anybody who knows, like, knows that I'm usually fairly quick, whether it's a couple hours or a couple of minutes. I'm usually fairly quick answering people, especially if you do it like before I get off screen or right after. I usually check them right after. So I'd be pissed if I was the jury right now with all this. Like, I do believe that another judge would have shut it down. Like, and she does look weak. I have to agree. Like, right? We hardly knew you and we don't care. Right? Make Karen do a breathalyzer. See how much Tito's she's had. Oh, I love when they say she's biased against the prosecution. I literally just laugh. She's been a defense-leaning judge long before this case existed. She was a defense murder judge, lawyer. She did murder cases. Like, so it's hilarious that they even claim that. Like, is that a water in your bottle or is it vodka? DePetro says defense sends an errand boy Alessi. It is painful. No, the judge is 100% caught on. I believe the judge knows exactly what they're doing. Let's get real here. Like, yeah. Yeah, I didn't get $170,000. I didn't get, you know, 50,000, 30,000, 20,000. Like, I do the best that I can, making the minimum amount that I make here. I cover the costs and I might make a little on the top. It goes to normal things like groceries, toilet paper, clothes for my children. Like, I'll tell you what it doesn't go to. It doesn't go to buying 7 phones to harass witnesses. It doesn't go to buying a Lexus because the Reed family or someone else slipped me lots and lots of money, or a story that they fed me, which was bullshit. So lots of people would give me the money to buy said Lexus. Like, I will check in a second. That was a good one. It was a good one, Jack. It was. I do my best here. I don't have the same options other channels have. So, oh, thank you, JMS. I'll check that in a second. Video from the people. I have it, Jess. If you give me, I can send it to you. It was also, I think, in Discord, if I believe it. I think someone put it in Discord, I believe. I'm pretty sure it was in Discord. Yeah, it's not free, darling. This thing that I'm on right now with the screens, this is $50 a month just to do StreamYard. It's like 48 and change after tax. Like, it doesn't, and then you have to pay for the thing that you make your thumbnails for. I use Imagine and I use Canva, so I have to pay for those two things for editing softwares and making the thumbnails. There are tons of costs associated with streaming. It's not just, I mean, I don't just press the button and go. You need equipment, like that comes to your like electric bill going up. I'm using lights. I have lights. I have two screens on. I have a microphone. You know what I mean? Like camera running. Like this is it's not. There are costs associated with this stuff, dude. When I pull records, sometimes I have to pay for those. Like, court documents, things of that nature. If I want to go to the court and I have to go get those records, then I have to pay somebody to bring me or an Uber or a Lyft. There are costs if you're doing it right. If you're not just spewing nonsense without doing any work. I'll check in 1 second, JMS. I'm just trying to get down to the bottom of these comments. Like, I agree with you on that. I've said that. She has no, oh, didn't they already say it was under review though? Like, how long could it possibly be under review for? I mean, how long could it possibly take them? Yeah, StreamYard's a paid service. You got to pay for it. Yeah, she was defense before this, before she was a judge. But I do agree that you don't have a right being a judge if you're going to rule from a place of worrying about appeals, like I am not. My body feels like I'm 75. Like if that counts, I have so many medical. See, we got nuked on Facebook. Yeah, exactly. The attached got nuked too. And then someone gave him a fake account, I believe. And somehow he was able to keep that. Like, oh, thank you, Jack. I mean, everybody has their cup of tea. I'm sure there's other people who would rather watch Kevin. It is what it is. Like, yeah, there's quite a few. Comparing Elise or anyone's TV is about the most vile thing one can say. I know, really, right? Like, especially me. That's like polar opposite of like who that man is and what he stands for. Like the whole thing. Like the whole thing. Yeah, I guess we are. She better cut that lunch break a little shorter or something because there's like no need. She goes like, oh, we got them coffee. Like, oh, that's great. Did you get us coffee? We have to deal with two, lady. Like, yeah, I mean, it's when you start spewing the false information to just appease people that we have the problem. All right, here they come. I'm going to check.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone.
Oh, absolutely, Insider Man.
All right. I appreciate the time. I appreciate people's patience.
Do you?
So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So
her
that's
methodology.
My decision. So bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that? Okay.
She said methodology that he could talk to her about, but it's not that's not what he wanted. We have an anonymous $15 donation. I'm not going to read the person's real name, so thank you so much. And then Potluck sends 10. Thank you, Potluck. I appreciate you, my friends. And then we have one for $50. And it says today for order some Chinese food from Mark. Thank you, Mark. You know what? I might. That sounds really good. I'm not going to lie. That sounds delicious.
Put it back in session, you may be seated.
Jurors, I appreciate your patience. So
Oh,
the
no,
next
poor
witness, Mr.
Kevin.
Brennan.
The
Poor thing.
Commonwealth calls Jessica Hyde.
Oh, here we go. We send Kevin our well wishes. I hope he's okay. Yeah, right. Karen scheming on how to get it in anyway after they were just told no. We do send all our love to Kevin. Oh, that's terrible. That's awful.
Just wait. All that officer right there.
And follow me, please. That's all. Face the clerk and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space HYDE.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate, I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device I was provided. Yes, not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
When you use the term artifact, what does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m., and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches.
Suspended
but
tab.
Browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Haas Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
This is how I explained it to you guys. It's not the time of the search. It's the time that the tab was either opened or moved to the background for another one to replace it. So like I know all the techie
Can
stuff is
you-
confusing, but that's the simplest
It's a paper
version of
you
it that
recognize
I've been able to
that.
sort of
I do.
explain
This is
to you.
table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the, that will help you explain?
It will.
Don't know, Bree.
Who you approach, or I've been a chat if you want.
No, she didn't watch it to 27. That was the last one that was on the tab when she opened the new tab for Hawk and Walk Sports at 227. She had played It's Raining Men in the house way before that. If that explains it. Oh, sidebar. That's 46 seconds long, so that's how long they've been sitting at that sidebar right now. Just saying. Yes, it's the longer version. It is the longer version of the nonsense. I don't know. I was explaining to you guys the tab, so I'm not even sure who called the goddamn sidebar at this point. Like, I'm going to assume the defense because usually they're the ones. But I don't know. But we do need the comedic effect once in a while. So when they call sidebars, I mean, we get the comedic effect. And of course, Freak was so kind to add in the dun, 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 circus music for me because I asked for it. We tip our hat to you. Thank you, good sir. Thank you, good sir. We appreciate you for our clips. This is why we have tech people, right? I appreciate you. I seriously do. I don't have the time. That's the problem. Why are we going back up to Fanny? What's happening? Like, oh, also Casey sent a donation while I was stretching my legs. I got up and stretched my legs, so I shut my camera off for a minute. But thank you, Casey. I appreciate it, my friend. She sent $6.36 and says, for your fine work, keeping us informed, and for having a great live chat. I agree. I think we have the best live chat on the internet. I'm just saying. Like, maybe we're tooting our own horn over here, like beep, beep. But I believe we have the best live chat available. So if you guys are, missing out on this live chat over on X, you should come join us because we have quite the comedic and educational in our live chat. And everybody looks out for one another. And I do believe it's one of the best, to be honest. Like, I don't know what I would do without you guys. If you want to donate to the channel, you can do so one of these ways: Cash App, Venmo, PayPal, Revolut. We have for people who are not in this country, or if you're in the country, you can use it too. But it does money from everywhere, all over the place, globally. So that's the option for you guys. There's also an Apple Pay link and good old e-gift cards to the email if all else fails, which is always helpful no matter where it's to. If you need to get in touch with me, it's twistedtragedies3@gmail. Remember, twistedtragedies3@gmail. Yeah, it's like talking to children inside our man. It's like, nuh-uh, nuh-uh, you said it first, nuh-uh. Like, I know both versions, but I have an old soul. One of my dad's favorite songs was Hotel California from the Eagles. So at my wedding, because he was already up there in heaven watching down on us, in place of the father-daughter dance, I played Hotel California, which was one of my dad's favorite songs. And now when it just magically comes on the radio, it's a very old song, so it doesn't come on often. I sort of know that's my dad's nod to saying hi, that he's watching, It's nice because, friends, family, like people will be out. Then all of a sudden that song will come on. They'll just call me and let it play to be like, dude, this song just came on. We were just talking. It's always when I talk about my dad that all of a sudden someone hears it. Like, I don't usually hear it unless after I'm talking about my dad, then all of a sudden it'll come on. Well, I like to think it's his way of saying hi. Oh yeah, they never, all they heard in the first trial when it came to the cult was 227. She said 227, so see, it happened. That's all they hear. They
Before
don't
we look
hear
at
what
any
she's
chalk, I
explaining.
want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just
Your
ask
Honor,
you?
may I?
See if you can answer the questions in a concurrent first.
Yes, Your Honor.
Why would
When
they let her
you look at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also use Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company, Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used Artex and Mushy. But Artex is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrite of last year, Celebrite made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, "How's long to die in the cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in a tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when the search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for Browser State DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD, CIKLD, CIKD, CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how long to die in cold" was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to,
How can you rephrase what's your opinion?
I'm sorry?
I'll see you at sidebar, Mr. Leslie.
How can you, what? That doesn't even make any sense. How can you rephrase, what's your opinion? How do you rephrase, what's your opinion? That doesn't even make any sense at all. Like, I mean, I do all the time. You can just ignore it, like it'll go away. You can't rephrase, what's your opinion? He said, what did you come to, whatever the question was. She said something, and then he said, that was your opinion? Yes. Okay. What was your opinion? How do you, and then judge said, Alessi says, objection. Objection. What are you objecting to? Her opinion? That's the whole reason she's there. She's the expert. It's her opinion. Like, the f do you mean? Judge says, rephrase. Rephrase what? What's your opinion? That's the whole reason she's there. She's an expert. That doesn't even, then I'll see you at, what do you, no. There shouldn't have been a sidebar. It should have been, actually, Mr. Alessi, what exactly would I have him rephrase that to? Like, I know I'm hungry too. I'm starving like a hostage right now. This is the time I start getting hungry and ignoring it to try to push. Yes, Mrs. H, that's exactly what matters. So I'm totally confused. That's why Hank was like, what? Like, come again? Like, excuse me? Excuse me? Like, how does he rephrase, what's your opinion? He made the foundation. It's not a foundational question. The foundation's already there. So what the hell? I'm confused. Like, I know, right? This would be a great ringtone. I'm not on mute. I'm only on mute when the song's playing. I'm unmuted right now. If you can't hear me, then that means you probably have me. You probably have me on mute. Yeah, what the hell? Like, right. Did you come to an opinion on it? Yes. Okay, what was your opinion? That's literally why we're there. She's an expert to give her goddamn opinion. So I'm totally confused as to what he's objecting to. Like, it was a crazy objection, Stacey, right? I was like, wait a second, I'm not muted. I had to look down for a second because I do it sometimes. I had to look down and be like, wait, am I muted? Oh, wait, I'm not. I do it sometimes, so I had to look down. Like, wait, I'm not muted, am I? Nope. Yeah, overruled, exactly. That is an option. Doesn't seem to be one she uses. I'll allow it, usually. But what the hell? It shouldn't be an I'll allow it. That should be a overruled. Like, this is absurd. I've never seen anything in my life. Like, I know, right? They can't hear you. I mean, it will at this point. The judge says, you know, we're ahead of schedule, and then what happens? And then this shit happens, and then you're behind. So this is why you don't let a jury go home a half hour early. This is why you don't just stop right at 4 o'clock. This is why if there's somebody on the stand, you wait a little longer past 4 before you cut it off at 3:58 and say you got 2 minutes left right at 4 o'clock. Like, come on, man. We're not even getting like a full 8 hours a day of this. Like, right? Objection. Her opinion is going to stifle this. Like, it's going to completely disrupt the entire defense corruption theory. Like, Your Honor, have you ever seen such a ridiculous objection, Joy, in court? Like, tell me you've never seen somebody objecting to the expert's opinion when asked, what's your opinion? I mean, if you have, that's insane. But like, tell me you've heard an objection like this before. Like, and again, she needs to stop allowing them to keep doing it. She needs to give them a good talking to at this point. Like, it's just absurd. Like, I know at this point, Hank's closing could just be like, she did it and that's it. Like, well, that's the problem is why doesn't the judge ever just say no. I have never seen a judge not one time say overruled or no. She just panders every single time. Take some, like she's so afraid they're going to appeal. They can't appeal on you overruling them on such a question such as, what is your opinion to an expert? Like, that is absurd. Like, unless he doesn't even know what he's following at this moment. That's his problem. If he has no idea what he's even going to say, he follows nothing Jessica Hyde is saying. Therefore, he just thought he'd throw in an objection. Like, what the hell? He might try to mess with her. The problem is she's probably going to look at him the same way the meteorologist did, which was like, he made a couple looks at him like, what the fuck are you talking about? Like this, like darting his eyes around, like, huh? I caught the cop earlier doing it where he was like, to Jackson, like, what the fuck are you talking about? Like, I'm confused here. Like, it's absurd. Like, it shouldn't be allowed. They're not supposed to be. Like, if she is texting, it better be one of her attorneys. Like, I mean, everybody in the courtroom is allowed a phone, but no, they're not really allowed to be like texting and getting outside messages on her phone and laptop. Like, that shouldn't, if that they're catching her, like, the problem is they have to catch her doing it. And you don't have one of the court officers standing behind her. It's because the court officers have to stand behind the Reed family and make sure none of their guests start a problem. And they have to stand behind the journalists now, because we had a fake journalist who sued to get his credentials, that should have already been pulled by now, using his laptop screen as a way to harass and intimidate witnesses. So now they have to have someone standing behind the journalist to make sure. Privilege, yes, but like, she doesn't, she shouldn't be allowed to have that privilege that the rest of the world doesn't have as a defendant, to be sending and receiving messages via text or laptop. Your attorneys are right there. So if I was the judge, I would say, like, I don't want to see you pick up that phone again to be sending or receiving any messages. Your attorneys are here. You can speak to them here. Like, I do agree. She needs to grow a set and be a fucking judge for once. This is obnoxious. This is a waste of the jury's time. Like, time for me to take my blood. It's like torture having to deal with this crap. We know you're not, Trisha. We know. We know. I got you, girl. I got you.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
It's hard for me to sit still too. Yeah.
In addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time, Mr. Massey, on this issue, okay?
That whole clip is 46 seconds and they're still up there. 46 seconds that clip is, and they're still up there. And I agree with Casey here, where it's like, okay, you're an idiot, Alessi, because all you just did was allow Brennan to show the jury how credible Jessica Hyde is. You absolute idiot. Like, what a moron. It is absolutely ridiculous, Maui. She should say last time on this issue, but let's be very clear. It won't be the last time on this issue or any other issue for that matter. She should have just said no. It should have already been done at the last sidebar. We're not going to go over this. You can't object to everything that has to do with 2:27 a.m. She's allowed. She's the expert. She's going to give her opinion. Period. Use a cross-examination. Yeah, she scolded him because they already have talked about 2:27 100 times. He just doesn't want her to say it didn't happen at 2:27 a.m. That's it. He's going to keep arguing that she shouldn't be allowed to say that. But the judge needs to stand firm in, yes, she can. It's her opinion. She's the expert. F off. You can cross-examine her. End of story. This sidebar should have already been over. Just saying. Yeah, exactly. Same shiitake 3 months later. Like, come on, man. Like, oh, I mean, she's just as bad as a sewer turtle when it comes to being online 24/7. He's online when he's in the courtroom. That's sad. That's why he doesn't pay attention. And that's why he can't explain anything properly. It's because he doesn't pay any mind because it's way over his head. Like, they can never undermine Jessica Hyde. She's too smart. She is too smart. Yeah, he does not want them to hear that 2:27 a.m. did not happen. Yeah, right is right. You know, this won't be the last time on this issue or any other issue. Like, yeah, the jury's definitely got to be pissed off. If I was them, I'd be quite pissed off. Like, you know? Yeah, he doesn't want the jury to hear the answer to the question. And that's very clear. It's definitely clear to the jury at this point. So good job, dumbass. Like, good job, dumbass. Exactly. Thank you, Joy. Most jurors are not dumb. They understand the defense is scared of certain evidence when the objections and sidebars start. If Karen is the victim of a big frame up, they shouldn't be bothered. Bingo. They're not dumb. They know exactly what's happening here. We know, they know. You know what I'm saying? Like, that's all he's trying to do is strong arm and bitch and whine like the baby back bitch that he is. And I'm sorry. I know a lot of people don't like swearing, but it's part of who I am. I swear a lot. I'm sorry. And it was warranted in this situation. The facts are the facts. And yeah, I'd be humiliated if I was defense. Clearly, they're not. They have no shame whatsoever. None at all. Like, they are shameless. Like, of course they are. It's what they did last time because of her headscarf. Like, what does it matter if she... Dude, they tried to say that me wearing blue eyeshadow is... Only middle schoolers do that. Good. I wear it every day now. See my blue? I use blue and gold today. It's beautiful, isn't it? Mm-hmm. Yep. I'm wearing it just for FKR. Just for you guys. Since you're such idiots. You really can't. You do it with the truth, Potluck, and that's the best that Hank can do is do it with the truth. And I think he's doing a phenomenal job. They're despicable and desperate, Anna. Extremely desperate. Like, yeah. No, period. Exactly. Stop interrupting the witness and enough. End of story.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So,
oh my God.
You shared that you have an opinion about whether that timestamp 2:27:40 was
first opinion
whether or not that was the time the search "How long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search "How long to die in the cold" occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Boom.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How long to die in the cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you have
thought.
an opinion, to a reasonable degree of scientific certainty, whether there were any other searches on that tab before the final search at 6:24:47, "How long to die in cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redacting aspect, but consistent with my prior objections, I would object to that.
Okay, I'm
Overruled.
going to allow this into evidence. Your right to say it. Mr.
Thank you, Your Honor. Appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Yeah, he does. Overruled.
Could we enlarge the first two?
Exactly, Joy. From my head
We're
to
going to need to get the
your
right
typing
column in if
fingers,
we can,
darling.
please.
Yeah, he objects just
Ty,
to
can
do.
you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column, it's a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, a cache record.
Mm-hmm.
What is the term? And what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 624.47 and also appears up at 227.40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 624.18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
And you offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
Overruled.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, how long to die in cold, was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed, so every tool chooses to do that differently. That does not mean deleted, it means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
An examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining is recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
Sidebar. She said sidebar. By the way, that's the way I've been explaining it to you guys this entire time, is the 201st one or the 101st one is deleted by the phone software, not actually deleted, but put into the background to make room for the next one. It's still there. It's just deleted from said screen. And she said sidebar. So that happened. Just sort of kick back in. What do you mean? You guys don't love my clip? You don't love my clip? You don't love my sidebar clip? You don't want to see that every time she has a sidebar? At least makes me laugh a little. But you are 100% right, Joy. Yeah, she's literally texting and receiving calls. You can see it in Zoom in court. I guess we're going to have to email the court and ask why she's sending or receiving calls or emails during court as the defendant. She shouldn't be receiving text messages, DMs, or anything like that in court. They are not allowed. No defendant is allowed to be doing that. She probably used the excuse that she texts her attorneys because they're so far away from her. But they're going to have to figure something out because no. Nope. Yeah, that's the best way.
I'm going to let the jurors have lunch. You can walk out after.
Thank you. Thank you, Your Honor. Thank you, Your Honor.
We'll recess for 45 minutes.
45
All right,
minutes.
for the court, please. Jurors, close your notebooks, follow me.
45 minutes. Like, are you fucking kidding me? 45 goddamn minutes. Like, right? Really, the last time, you know? Yeah, I mean, they go and have drinks during lunch because that's like super smart of someone who's, you know, on trial for DUIing. You know what I'm saying? Like, yeah, nothing can really be truly deleted unless you brick your whole phone, which she did attempt to do the second time they came to get her phone. Yeah, I mean, I do too. I do love the music. It's the best explanation I could give you guys this entire time. Yeah, she has been, Joan. So that's the best explanation I could give you guys is how it wasn't user deleted, but software phone deleted into the background, you know? That's the other thing. Like, you're doing it in front of the jury. Like, I'm confused here. Like, oh, it made me hungry. I'm not going to lie. What are we asking me? What happened? What did I do? What did I do? Yeah, Hank said he had no more questions. If I was on the jury and I'm seeing her send and receive messages, like, that's a serious issue. Like, that's a very serious issue. So I don't think it made it confusing. I think it actually made it so that people could understand. Because if she just said it the way it is, like tech-like, nobody would understood anything she said. So I think it was brilliant actually to explain it that way, because many people are not going to understand what she's saying otherwise, unless she uses something that people can understand. Yeah, 40 exactly is 90 minutes to her. That's for damn sure. Like, yeah, you just can't. Like, there's always going to be a record. Like, I mean, unless you are that tech savvy, okay, like, then it's just not going to happen. Like, so, I mean, I think, again, I know Jessica Hyde is brilliant. She, the defense, of course, does not want her to say anything about 2:27 a.m., I guess. And this is thank you to Francesca. I see this in my Discord. Melanie Little apparently blew a gasket when the motion was denied for Alessi, and she decided she was going to give the whole stream like 2 middle fingers and say she's done with these people and the judge is corrupt against the defense, which is the funniest thing I've literally ever heard in my life. But she freaked out, of course. What a loony bin. I told Francesca in our Discord to tell her to stuff her pie hole with her blood money donations while she's at it on her channel, freaking out about a ruling that should have been made the exact way it was. So just saying, like, I don't know how anybody watches that woman. It's cringeworthy, in my opinion. I can't do it. The fake like facial expressions she has to turn to the whole side to do. Like, I cannot do it. I literally can't. I don't know how anybody does. Her voice goes right through. I can't do it. So bless your souls if you can sit through 3 minutes of her, because I cannot. I literally cannot. Like, go for it. Have your luncheon break. I usually don't have mine until after lunch is over, because I'm here with you guys for, the time that they're having lunch. And so I don't usually try to figure out what I'm going to do until after they come back from lunch break. But yeah, no deletions is the main thing that happened here, Yeah, I can't either, Maui. It's like something that like makes me cringe like right away. I'm like, I can't do this. Like, I cannot. Also that, and now that I know that she uses like a filter on top of a filter on top of a filter, usually a filter, like I have StreamYard, and yes, my filter is on. I have more like redness in my cheeks from rosacea. And you might have like blemishes on your face. So all it does is like even out your skin tone, really. But what it doesn't do is it does not get rid of like anything down here. If you have like third chin, it doesn't get rid of that. It doesn't get rid of a ton of wrinkles. It might smooth some, but it surely doesn't get rid of like baggy skin, or like, it doesn't do that. So you'd have to use a filter on top of a filter to actually get rid of that. So looks like she's been using like a filter on top of a filter. So yeah, everyone's part of the setup, except they can't accept the reality that Karen herself is the one who hit John. Like, I have no, she was like also like a failed actress. I don't know if she had something to do with vitamins, but I do know she's like a failed actress and then became some Lawtuber. She used to do like civil law, or does do civil. I don't know. Either way, she's not very knowledgeable in my opinion, or she just lies a lot. One or the other. Like, yeah, Streisand effect. one or the other. I don't really know, to be honest. But there's John, who gets lost in this whole giant circus of nonsense. But there he is. His badge number 4920. I could ingrained in my brain now. And yeah, they did file a lawsuit, John's family, against Karen, wrongful death, and make no mistake that that's going to go forward. And the bar for evidence is much lower in a civil case. There's no doubt Karen will lose that. She will not win that. Mark my words. That's my opinion. But there are so many more lawsuits coming for some of these people. They have no idea. They just keep saying, like, acting like it's some joke that'll never happen because it hasn't happened yet. And that just shows you the knowledge and ignorance of some of these people when it comes to law. Most people wait for a civil case until the criminal one has sort of almost finished before they go after a civil lawsuit for a multitude of reasons. But it just shows that they have no clue what the hell they're talking about when they're like, well, it hasn't happened yet. Nobody's sued me yet. So I guess that means I'm right. I'll take no for 700, Alex. That's not what that means. Not even a little. And I guess they're in for just a damn rude awakening when those suits come for them. And I know specifically, at least, Karen and the sewer turtle are going to be buried in them for years to come. Hopefully both from their jail cells. Because that's the best we can hope for at this point, is both of them sitting in their jail cells while they await losing these civil suits that they will have to pay the rest of their lives to give back to their victims. And make no mistake, when M. William Phelps in his last podcast about this said there's over 100 victims, he's not wrong. I think it's well beyond even 200 probably at this point when it comes to those two. And I would even argue their lawyers haven't helped, and they certainly have lied to the court. They have not had candor to the court. They have misled the court. They have misled the judge. And I don't think that's going to fall upon them kindly when this is over. I think we get frustrated during trial because we're not seeing the, ramifications of what should happen when lawyers do this shit. But I do fully believe that when the case is over, we will see something when it comes to these attorneys have to deal with some sort of something, whether it's having a BBO hearing and complaint, which I fully believe will happen. I don't have the greatest faith in the BBO, and I don't think really anyone does at this point. A lot of times the BBO makes excuses for their attorneys because they're all attorneys themselves. They explain away a lot of behaviors by saying, oh, it could be an accident, or, you can't prove it's a lie. Even if you've sent them proof that it was misrepresentation and a bold-faced lie, they'll just say it was a mistake and nothing to see here. And so I think that's why many people don't really believe in the BBO in the way that it exists right now, because it isn't actually getting bad lawyers or bad judges and pulling their bar cards and stopping their license to practice. It essentially just says nothing to see here, move along, and allows them to continue practicing. The worst case scenarios are usually ones where they give them a public admonishment and say, you can never do that again. How horrible of you. Don't do that publicly. Which does absolutely nothing, because they know they can just continue to do it again. And that's all they're going to get once again, is a public admonishment that nobody even really watches. So who gives a shit? Like, that's why they get away with what they get away with, because there's no real consequences to it. And to me, that's unacceptable. This is why the BBO can't be run by attorneys. It needs to be run by people who know the law and know the professional standards of conduct. But you can't just allow practicing attorneys to police practicing attorneys, just like we can't let police forces police themselves. It's just common sense that that's going to happen, and people are going to cover for each other if you do that. That's why you're supposed to have outside agencies, independent people do these sort of investigations into these things. And I just don't think it's appropriate that we have lawyers sort of policing lawyers, because they're always going to cover for them, because they're always going to think, well, it could be me, or I could have been caught doing X, Y, or Z, when they weren't. So no one inside for Karen. Oh, I don't know. Funny though, like, One person, well, there was this morning about, what did we say, 15 or so people outside this morning. So they must have got bored and left already. Not a shock to me, but maybe they got bored and left. You know, like I do have to think that even on X right now, I'm hearing that people are just making excuses for, it doesn't matter if 2:27 a.m. didn't happen because Karen still didn't hit John with her car. Like that's their excuse, is like, she still didn't hit John with her car, even though evidence proves that she did. And then when the car evidence comes out, they're going to say, but the FBI said that didn't happen. So screw what the car evidence says. The FBI said that didn't happen, except the FBI didn't say that. They never have said that. That ARCA is not the FBI. Okay, number one. Number two, they were tasked with answering only 2 questions. Number 3, Dr. Rentschler absolutely said that he could have been hit by the car and then hit his head. Absolutely 100% said that could have happened. They like to forget that that was said. You know, so it is what it is. The best we can do is keep pushing for justice and putting the truth out there. And there are those people that are just going to keep saying things they're not true, no matter what evidence they're shown. You could show them a video of Karen right now hitting John, and they'd say, that's not Karen. It was faked. Where's the timestamp? This is from years ago. This is someone else's car. That's not Fairview. This was made up. It's AI. It's doctored. The Commonwealth found it now. Oh, it's definitely fake. Like, you would hear 75 excuses about why she still didn't do it. These are people who are not willing to actually look at facts and realize that they have been duped. They have been lied to. I think because maybe it's harder to accept that you fell for it. Maybe at this point, like, yeah, maybe it's possible, but there was only about 15 or so people out there this morning anyway. Like, you know what I mean? So yeah, they say all the interview clips are AI when like everyone on planet Earth has watched it. Like the excuses they make up for some of this stuff is freaking amazing. Like it's absurd. Like it is very disturbing and disheartening to see how gullible people are and how far they're willing to take something, even when given the proof that that thing that they keep saying happened didn't happen. 2:27 a.m. has been debunked since the first trial. Okay. How many times have you heard people say, but the FBI said 2:27 a.m. happened? The FBI never said 2:27 a.m. happened. The only person who said 2:27 a.m. happened was Richard Green. The only person. He is not the FBI. Let's make that clear. And the FBI or the Fed's U.S. Attorney's Office closed the case because they found no corruption, no collusion, no planting of evidence, and they cleared the witnesses. Cleared. Do they understand what cleared means? The mental gymnastics that you have to go through for this. That's a good question. The sewer turtle, maybe? I don't know. Like, it's a good guy.
Hey, what's up?
Hey.
I mean, I think it was very interesting that he was trying to limit her opinion on how she would answer for the 2:27. I'm not quite sure what his goal was. I know he was trying to admit, like, you know, a case that's kind of unrelated to what she was doing as the way to refute her, but I don't understand why there was so many sidebars when it comes to her scientific her opinion. Yeah. That was kind of weird to me because it
shouldn't have been allowed, though. That's when the judge should have said, no, Mr. Alessi, this has already been argued. I'm overruling you. Your objection is noted. Carry on.
Yeah. I mean, like, in the end of the day, I don't think there's a problem with him grabbing an article and trying to disprove her based upon that. I don't think that's the big issue. I think it is trial by ambush. He should have probably showed that way earlier.
Yeah, but he's misrepresenting also what it's about.
Yeah.
Herrera wasn't even about that same issue.
But you know what? In the end of the day, I think he's gonna mess himself up by doing that, because he's gonna enter that in, and you're not dealing with Mr. Green, you're dealing with a lady that's extremely smart and very competent in her field of study. And I don't think it's gonna make him look really, really bad. I think it's a very bad play what he's going to try to do with this. I think he's going to realize she's going to like run circles around him because he's not as smart as this lady when it comes to this testimony. Maybe he could do that with Mr. Green, who's an idiot.
Right.
But I don't think he's going to be able to do that. And she's going to dog him, walk him around the park. You know what I mean? I don't think it's a very smart tactic.
No chance.
And I think that, basically explaining that none of these things could be deleted and that this is the last time with 624 makes, I think it's unrefuted. And I don't understand why they fight so hard for this particular aspect of the trial, where the aspect of the trial they should be fighting for is the accident reconstruction. Can you bring up reasonable doubt on what happened to John? Stuff like that. Not this whole 227
227's been dead for a while.
Because you have so much credibility with the jury. And if you're just losing it there and you're wasting the jury's time on this stuff,
wasting their time.
Yeah.
Sorry, I'm trying to turn the fan on.
Yeah, they got you dead to rights on it. You got to pick your battles here. And this is not one battle you should pick, to be honest with you.
Well, what he did was draw more attention to the fact that they were trying to hide her opinion on the search. That's all he did. That was not smart lawyering, at all.
I think this whole thing.
Victoria George is no longer listed on David Yannetti's webpage, and her LinkedIn now just says lawyer. Interesting. Was she fired already?
Probably. I wouldn't be shocked, to be honest with you.
Hilarious. That's hilarious.
I think it was a publicity stunt that didn't go too well.
Yeah, but wouldn't you still keep her hired for a while just to prove that it wasn't? You know what I'm saying?
Well, she could be just incompetent and he doesn't want to pay her money. You have to realize this case is probably draining Mr. Yannetti's funds a lot.
Which is exactly what I believe, I believe she's completely incompetent and crazy. That's what I believe.
Yeah, this is not a money-making case for these lawyers. They're, the amount of billable hours they are using up that they have not been reimbursed for is probably a lot. When you think Jackson got paid $250,000 for the amount of billable hours they've been spending, that's really cheap. I could tell you if, for 3 years of trials like this and all this stuff, that is
maybe
ridiculous.
that's why Yannetti looks so checked out, like he's completely done with all this. Because at this point, he's like, I'm not even getting fucking paid anymore. I only got paid $200,000, and Karen didn't think I was worth that $200,000 to begin with. So I'm done with this.
Think about remember she said I had they're just volunteer they had to correct them as billable hours. So I'm thinking they're volunteering their billable hours to this lady, and she's barely paying them.
I still believe, we know their lunches are paid for. We know their transportation is paid for. We all know that. That's already been publicized by them like idiots. So I do believe they're getting paid something. Maybe they're not billing their hours, but they're getting something. They're not all doing it for zero.
No, they're not doing it for zero, but I don't think for the amount of work they're doing, this is a lot of work they're doing. Lot of work. And
I also think they're floundering at said work, but
yeah, and the problem is that they are attempting to argue a grand conspiracy when the real argument should be, bring a reasonable doubt to that there was some sort of, fight that occurred that just so happened to happen. And it was just this last minute thing. And, but this whole thing, the more they talk into this grand conspiracy, the more I think they're losing the jury. Because you know what I mean? Because now what's going to happen when they have the dog bite expert come up, and then you compare expert to experts when it comes to the Commonwealth and theirs, and I think it's a really bad. And I think they're supposed
in my mind, I almost think they don't even call Marie Russell anymore. It seems to me as if they're trying not to call Richard Green.
I think they're probably going to have to call an expert, but because if they just leave it at that.
But they can't get a new one. You can't get a new one right now. It has to be one you've already had.
No offense. This group of people, the judge has been allowing them to do a trial by ambush on a constant basis.
She has, but to try to get a brand new expert in the middle of trial, that's not going to happen. It's
you never know.
This judge, it is not happening.
You know what? This judge has been so lenient when it came to the defense. I wouldn't be shocked if she allowed them. It's getting to the point of ridiculousness. Like she's just so afraid of an appealable issue that she just lets them have their way by every single means of trial by ambush.
Have you ever seen a trial? Have you ever watched a trial, V10, where a judge doesn't like when they ask to be heard at sidebar or they're objecting? Have you ever seen a judge not just be like no or overruled and just give them a sidebar every time?
Well,
I've never seen anything like it, like ever.
I haven't seen anything like it, but I think like a lot of I think though, if you think about it, what has the defense done to chip away to prove a grand conspiracy?
Nothing.
I mean, really nothing. They made this promise, and honestly, I think that was a tactical error. I think they should have focused on a rush investigation and just left a little door open to possibly anyone could have done it. And this whole thing about, you're pointing the finger, and this is what like people don't understand. Like, yes, reasonable doubt. You just have to prove reasonable doubt. But when you have a defense that is saying that they are pointing at people as the perpetrators, now the jury's going to expect you to put your money where your mouth is, to prove to them a little bit, to show that there's evidence, to show what you really want to show is if the police should have pursued that investigation into these people based upon the evidence that was available. And thus far, they have shown nothing. Karen Reed did not make a statement that he went to the house until much, much later. There was no evidence of a struggle in the house. There was no drag marks in the house. There was no blood in the house. There was no real change. There was no change in what the people stated. So this did not cause the people to, like the police officers, to think to themselves, we need to investigate the Alberts. We need to investigate Higgins. We need to investigate Jen McCabe. And like that's the big problem with this third-party culprit defense, because it's really the idea of a third-party culprit defense is really to say they should have investigated these other people, and there's reasonable doubt at this point.
Yep. And I mean, Freak's right. What punches have they landed? There's been no gotcha moments like they thought. Like they thought they had some gotcha moments and they landed completely flat. Like there were no I gotcha moments. Like they have landed nothing.
I mean, they're mostly like if someone, like we're in a boxing match and they were just grabbing on, for dear life at this point.
That's literally it. Like grabbing on, like, okay, this is today, right? The only people I see are the normal Turtle Boy's girlfriends, the Sewer Turtles, Mr. Burns' wife, Smithers. Doesn't seem like there's any like other randos there. And the Sewer Turtle sends his girlfriend because he's not there.
Yeah. I mean, I think
work. I mean, her job just lets her sit in court all day is what I want to know.
I don't know. I think any woman that goes into a relationship that is a multiple cheater and a man that treats women and puts his hands on women needs to reevaluate her life.
Yeah.
I mean, the man left his wife and kids to pursue mistresses, and he puts his hands on women. I don't think he's a good man.
I'm pretty sure that his wife left him this time, but it was like her last straw of like time after time after time.
Well, he made the decision to leave his wife because he cheated on his wife.
Agreed. Yeah.
You know what I mean? Like she just followed up with it. She's not going to deal with that type of ridiculous behavior.
I wouldn't. I don't know. I honestly don't know how she did for so long. I'm sorry, but if my husband did some shit like that, bro, like it'd be first one and done. See, nope. Because the longer you allow them to do it, they think they're going to keep getting away with it every time. Get the fuck out of here.
It's the fact of your, and that's the type of character you have with this guy. The guy is, to me, in my opinion, the lowest form of human. But I did see on Twitter that they're fighting. JLR and Mr. Turtle Boy are fighting. Apparently, JLR says he's going to be there for his hearing. It's like when he goes to jail, and Turtle Boy's like, "You're not going to show up." And the problem is, Turtle Boy, he will show up.
Mm-hmm.
He will show up. He will show up, and he will fucking troll the fuck out of you.
That's great. That's great. So JMS said she saw Bob Motta on YouTube and has been he's been definitely FKR supporter. And even he said to his wife, Jackson needs to change his strategy. This conspiracy thing is not working. Wow. No. Have I not been saying this since like the first day of trial? When
you do a third part, just like I said, you need to say that the police should have investigated another aspect of the investigation that they didn't. Now you can, and if you can even make it like, you can make it fit that Proctor was so rushed to get this investigation done over that he might have tossed some taillight pieces or whatever in their grand conspiracy or something like that. But the fact is like it's incoherent because all their efforts are pushed onto a soccer mom of 3 girls.
Right. Or Carrie Roberts, who wasn't even there that night.
Carrie Robbins and the ambulance attendant to, you know what I mean? The EMT.
EMTs and the firefighters.
I mean, it gets to the point where you're sitting there. It's like,
absurd.
and then it kind of undermines your credibility when you're going after these people so hard about I hit him, and then your client's on TV saying, yeah, I did say that. I don't know if I said that many times.
Yeah.
You know, it's really just, and I think the most damaging thing about this whole second trial is her own statements. I don't think there has been anything more damaging than her own statements, to be completely honest with you.
I agree. There's nothing more damning than her own statements. Yeah, I do think that a lot of the zombies are just the like main core ones that are left. I agree with you, Potluck. It's just the ones that will always exist around him. They need that sort of pat on the back, that a boy sort of thing. You know, but yes, JLR will show up. So he's an idiot. He knows that though. So he's just, you know, he's trying to wish into existence that he doesn't show up.
And you know what? JLR's saying you have no idea what type of prison you're getting into. I would take JLR's advice. He was in 10 years in a federal pen, I believe.
He was, yeah.
And they had to force feed him at one point because he wouldn't eat. Like he is another type. That's why I say like Turtle Boy doesn't quite understand who he's messing with. He just really doesn't.
Apparently not.
You know, he thinks that he can shame JLR by showing his like videos and stuff like that. No, he does not
shame
give a
someone
fuck.
who doesn't have shame, especially if they've moved on in life. Like I love when he tries to shame people who used to be addicts like me, and I'm like, bro, it's been almost 20 years. Like I'm 2 years shy of 20 years. Like that was a whole nother lifetime ago. I was 18 years old. I was young.
JLR is Jonathan Lee Riches. He has a 400K, I think, sub channel. He blew up during the Cavalcante and all that stuff. In the early days, he what we referred to him as like he basically hung out with Bullhorn Betty and all these people, just harassing parents and stuff like that. And eventually what happened was, I guess he moved on from that and just did like live coverage of the border and stuff like that. He got a new girlfriend. At one point he was dating Bullhorn Betty, but they kept their relationship secret. He moved on to Magnolia, who probably told him not to do stupid shit like that anymore. And they moved on to other content and they grew from there. They covered the border. People like their border coverage. People like their Cavalcante coverage. They like generally a lot of his stuff. But you have to realize the early days of JLR was crazy. Like this.
Yeah, I heard that he's grown since then. I mean, I don't really know much.
Yeah, I mean, this is a guy who did things that Aiden would fucking probably be like, holy fuck, I can't do that.
He'd crawl in a hole and cry to the police that he says are, you know.
Yeah. I would say JLR in his early days was 10 times worse than like what Turtle Boy would do. Like, but then he said, I'm not doing this shit anymore. And he moved on to other content. And that's it. And the reason why he did 10 years in jail is because he did stuff called phishing. I think it was millions of dollars he got through phishing
like links,
people.
Email links?
No, phishing like credit card stuff. And so,
yeah, that's what I'm saying, like email links, like phishing, like click on the link and they get all your information. Yeah.
Something, I think it was like literally it had to do with, you know, like when you swiped supermarkets and stuff like that. He figured that out. But yeah, this is a guy who got in trouble. And then he got so fucking bored in jail. JLR just filed frivolous lawsuit after frivolous lawsuit. I think like thousands and thousands. Like he sued the Statue of Liberty, Holocaust survivors, Nostradamus, you know, like literally every single Kim Kardashian, OJ Simpson at one point. No, he's not FKR. He hates.
No, he actually came last trial and was asking Karen on camera if she feels any remorse for what she's done to the O'Keefe family and to John. And of course, there was no response to that. But
yeah, he thinks she's guilty, and he absolutely. And they think they can like shame him and attack him, and it's like, you don't know this guy. Like I looked into this guy. I read his filings for OJ Simpson. At one point, he claimed like OJ was an alien, and he was trying to make orange juice from people, and he was like a clone. And at another point, he was saying that he had like Kim Kardashian sexually assaulted him, so he was going to sue Kim Kardashian. Like he filed like thousands and thousands of lawsuits. You can read his filings. It's crazy.
Where the hell do you get the kind of money to keep filing frivolous lawsuits?
Well, he found a loophole that since he was in jail, he didn't have to pay the filing fee.
I mean, you can claim indigency.
So back then he didn't have to. He found a loophole. So it cost the state like $300,000 because he would just keep on filing them and never pursue them, because they would get dismissed. And that's when the judge said, "Holy, it's beats him." And that's when the judge said, "Hey, you're not allowed unless you have a legitimate lawsuit." And what happened was his most recent lawsuit he did with a guy named Unirock grabbed a picture of JLR with like underwear over his head or some stuff like that and made fun of him. He did a pro se litigation until the guy just, lost all his money and then just not pursued it anymore. That's what I mean. Like the guy is like,
that's the thing. Like, I mean, here, the funny part about it is what he's doing is sort of punching down on the sewer trickle at his own game.
Yeah, it's like seeing Godzilla and King Kong fight. It's like, I would say JLR is like, Godzilla, and, Aiden Kearney is like King Kong, who's going to get just decimated in an actual fight.
Yep.
And yeah, so that's like the history. And he moved on from that. I mean, obviously, but the fact is, like, that's why it's kind of funny to see these two kind of fight, because you're sitting there and you're not really rooting for anyone. You just kind of just want to watch the shit show happen.
It's like a train wreck you can't look away from. It's just happening. You see it going towards each other. There's nothing you can do but look at it. Like,
yeah, but like, yeah, man. But but when it comes to this case, it's very interesting to see a lot of people who are just, I don't understand why people don't think the conspiracy makes sense at all, because I don't think the defense has done a good job.
Not with the evidence. If it was pre-evidence, I could see, okay, because I was there, right? Like, but being fed misinformation. But if you get to the point of actual evidence coming out, the evidence doesn't fit the narrative. It does not fit. The puzzle pieces do not fit into the conspiracy narrative. All of those people have to be involved. Carrie has to be involved. Jen has to be involved. The EMTs, the firefighters, everyone has to be in cahoots in order for the grand conspiracy to work. And the problem with that is you can't keep 3 people to shut their mouths for a month. You think you're going to keep 100 people for shutting their mouths and not having one crack in years? I mean, come on.
They should have picked and choose their battles. They should have never went after the EMT workers. They went after the certain people. They should have kept it very simple to a fact of maybe they had a fight. John got hit his head. They panicked. They left him in the front, and then
or like she dropped him off. She doesn't even know what happened, and maybe it was a neighbor. Maybe somebody did something and stopped.
Shocker, she should have just admitted that she hit him with the car and then got 2.5 years max, maybe less.
18 months, she would have got out in good time in less than a year. So
she would have been out by a year ago.
15 days here in Massachusetts on every 30 days. You can get 15 days of good time in state prison. So,
I mean, JMS, I'm worried. Yeah, I mean, you could be worried about like a cult member getting onto the jury, but in the end of the day, if that was the case, then it's already done. It doesn't matter what is said in the trial. There's going to be another hung jury. And I think that's what Mr. Hank and Yannetti and Jackson and Alessi and Little are hoping for. They're hoping that there's going to be another one person that stands out and says, well, I don't believe she did it. The problem is it's going to be tough.
Yeah, it is going to be tough. You can't be one reasonable person to say you don't think she's guilty on any of the 3 charges. Come on, man. That's just not gonna. You're giving yourself away as someone who's a plant on the jury at that point. Like,
I mean, I think like I think there's a good chance, in my opinion, but obviously she's drunk, obviously, and I think that there's a good chance that they will be the DUI, manslaughter, whatever, could be one of those things that the juries be more focused on. Maybe the problem is like are they going to still do the consciousness of guilt charge?
I'm not sure. He has not asked for them to read the consciousness of guilt instruction yet. So I'm not really sure. Yeah, where that's going to go if he's going to do it, I don't know. And CGC, if you don't know where the evidence lies, you're probably just here to troll. She's gonna Sarah Boone this shit all the way down.
We sat there for a week and
not to mention, if you scripted a timeline and people's testimony, you would have 0 inconsistencies. People's memories are not perfect. Little details are very often different in the group. Yep.
you have to realize that Jackson is a high-priced attorney. He knows what he's doing. You're dealing with 4 different attorneys basically working together. And guess what? I guarantee you, if you asked me exactly what I said this morning on this live stream, I wouldn't be able to tell you, and I'd probably repeat something different. You know, unfortunately, that's not how human memories work, and that's
the
why
point. There's supposed to be different inconsistencies, and that's the point. Is they're supposed to be in human memory. If they were lying and it was scripted, they'd be saying the exact same thing every single time because it's scripted. That's how you can tell that it's not. They're using different adjectives to describe. You know what I'm saying? Like, that's normal of a human memory. What's not normal of a human memory is to say the exact same thing every single time, no matter what. Like, saying it and describing it differently, that's normal. Using a different adjective to describe it, but that's where the defense goes, is they want to take that adjective that you used and say, but you said this last time. And it's
I think though, like, the worst attorney, in my opinion, I think the person that's probably not getting the jury's attention the most is Alessi. I think Alessi is really not good with person. He's probably very good at finding case law and arguing it and stuff like that in front of a judge. Well, you know, like getting case law, I would say he's probably very good at that. But I'm saying, like, when it comes to like crossing people, he's terrible. He's worse than Unetti, honestly.
You think he yells objection in his sleep?
You know what? It could be. Remember that movie? What was that movie? Was where like the lawyer's giving advice to law students, and he's like, just like say objection for everything, and then he goes to sleep during trial, and then when he wakes up, he just says objection.
Yeah,
objection.
I swear to God, when I think of Alessi in his sleep, just jumping up and yelling objection. Like, what the guy? Like, yeah, so that's the thing. Trevor's right. He's good at boring you into not really understanding or following him. And that is going to hurt the defense. I don't know whose bright idea it was to have him cross all the technical experts, but it's a failing idea.
Yeah, because I mean, like, the problem is that he just doesn't capture the jury's imagination and to simplify questions that they can understand. You want someone like Jackson to kind of do crosses of those types of important witnesses to kind of, you know, cut through the bull and get to the meat and potatoes of the whole case.
Right.
I don't think like having Alessi bore the jury, and who honestly looked ridiculous trying to like grab, you know, meteorologist, like, you know, he grabs these like papers, like, you know, these binders of like, oh, published peer-reviewed published document, and tries to hand them off, but then he doesn't quite understand the documents he's handing off to these witnesses. No,
and he doesn't quite understand that you have to give them to the prosecution first, and it has to be okayed. You can't just like hand documents to a witness and say, here you go, like, you know what I mean? Like Jackson's stunt with Jen McCabe's like, this is 225 pages long, so if you want me to read all of it, I'll read all of it, but I'm not answering the question until you know what I'm saying? Like, sorry, not sorry, guy, like. And yeah, Karen outside the courthouse saying Jen's lying. Like, she knows what she's doing. Okay, she freaking knows.
Well,
what
I mean,
she's doing. Like,
and she, you know what, Karen Reed incriminated herself again, like last trial. Remember when she backed into her car, and then the news reporter asked her, "When did you break your taillight?" And so, didn't you see it? I broke my taillight on John's car, and it's like,
Steve. It was when we backed into his car, and then her own expert said that could not have been possible.
Not and now they can
watch it. Her taillight goes past his car,
and now they can use that against her. And it's like so. And you know what? It also shows a consciousness of guilt because she's doing a cover up afterwards. She's attempting to cover up her crime because she knowingly knew that she left that man out there to die by doing that. And also, I truly believe that, you know, she probably deleted her video pulling into the you know,
there was a couple videos, not just one, but a multitude of them that were deleted between the time she got home, and they were in between other ones, so they didn't just delete themselves, you know what I mean? Like, the only person with motive or means to do it was Karen herself. And it's a good point, Beauty Queen. She could have just walked up to the door, right? Why didn't she go up to the door and ask Brian Albert to come outside as a first responder?
The problem with her is that she never ever stated to anyone that he was in the house.
Nope.
She was expecting him to be on the side of the road.
That is said, right?
Terrible. That is a
that was
terrible
probably
statement.
the worst clip thus far. Is I was expecting to find him on the side of the road. If you thought he went in the house like you claimed, if you thought he was walking home, why would you think he was walking home? Because that's an excuse I keep hearing from the cult. There was how many people inside the house? Why do you think he would be walking home? Why would you think that she would think he would
in
be
the middle of a nor'easter?
Come on, man.
I mean, like, okay. It's on a sunny night. It's on a,
He has to develop it, but I'm not sure where he's going to put that in. That's my point. Is I'm not really sure where he's going to put in the consciousness of guilt and have the instruction read, because she did already ask him if he wanted the instruction read a little earlier. So, I mean,
I think what his tactic is he wants it. He probably, if I was to guess, Mr. Hank Brennan's narrative, he probably wants to read it towards the end while all the evidence is together and they can put the whole picture together. If he reads it in the beginning, if he reads it in the beginning, they're not going to quite make the connection. The connection.
You have to have the whole story first and then read the consciousness of guilt, like instruction to the jury at the end there. Like when it's all wrapped up in a pretty little bow, like I'm sure he wasn't advised to tone it down. And even if he was, he clearly never does tone it down. So I feel like he just knew that witness was a very chill guy. And I mean, at least at some point, somebody must have pointed out hey, even if his own team, probably not the court, but his own team, you might want to bring it down a notch, bub.
By the way, someone says, clueless, all of you. I'm not sure. You have to point to the things you're actually talking about.
Yeah, we're all clueless. You got us. You are a brainiac. You're a genius. Let me tell you.
Well, it is what it is.
Hence why your name is Party of One.
Well, he's by himself. By himself. Just like the lone protester in the corner. Just like maybe he's the lone protester in the corner. He's on his phone right now and he's like, Party of One.
You guys, I just went into Twisted's chat and I wrote something so funny. Go see it. Oh, wait, it's gone already.
Well, it's just funny. I wouldn't even delete it. I would probably highlight and just laugh at that person, to be honest.
I usually do highlight it first and then laugh, but I'm not quite down to the bottom yet.
Yeah, okay. All right. But I think I think it's gonna be a tough road for the defense. I don't know what the tactic, if it's gonna be the same as the first trial, but with
the losing tactic.
I don't think, because most of the jury didn't believe it. And I think Hank is doing a way better job of putting together a picture.
Yeah, I do. I think that as well. Yeah, and the ring witness, I'm dying to hear what the ring witness says.
And you know what? Proctor, I think, is going to be a bad witness for the prosecution. But you have to realize that the guy has probably reflected on his testimony previously, and he probably is better prepared than the first time around. Like when you know exactly how the guy's going to go at you, then you know what to do. You know what I mean?
Right. That's a good point. She never texts Higgins. She texts him to say John's dead or calls him or whatever. I think it's a text, but never calls Higgins to say hey, did John leave? The buffalo on the prairie thing. It is amazing to me.
Yeah.
Karen looks faint. John DePetro said that Karen looks faint. Yeah. Shocker. I would be, if I were her too, I might even do a whole passing out so I could get out of being in court today. Dramatic.
Well, I mean, what's happening is that this expert, I believe, I forgot her name, the lady with the turban.
Jessica Hyde.
Jessica Hyde, thank you.
Yeah.
I think she's a great witness because she is breaking down complex mechanisms in very simple terms. That means that she has a higher understanding of this technology. And I think Alessi's going to get himself into big trouble, because I think he's going to have a gotcha moment with this, document, this ruling or whatever he's going to show. And I think he's going to be open. He's going to look stupid.
Someone tell Bob Motta he needs to actually follow a case before he opens his big yap. Because he said something stupid like Higgins sought out Karen. False, sir. False. Karen sought out Higgins and took his number out of John's phone. We already know that.
Yeah, and try to.
If you're going to be FKR, maybe follow the case, sir.
Yeah, I'm hoping that someone actually reads the texts again, exchange with those two. That was hilarious to listen.
They're going to have to, but
bushwhacker. We called the bushwhacker.
It's called the reed whacker in my Discord. It's a channel about this case, and it's called the reed whacker.
Oh,
she just wanted to name herself. That's just, you don't give yourself nicknames. That's not the way.
You are so hot. You
Right?
are hot.
Like, what the hell, dude? Like, I can't. Like, I don't know if the prosecution will call him or if the defense will call him. I also don't know if they'll read those texts, though, because they said Nicarino, that was the last time they were recalling him, and he was the one being recalled to read the text. So I don't know. Unless they stipulated to them, I'm not sure. Like,
Yeah.
I don't know. Oh, you know what? They might have him read them. That's probably why, because he's going to read them. Unfortunately, him read his own texts.
Maybe. I don't know, man.
I think that's the one thing, B. Harley, that sort of shows the jury that, like, no matter what, and Hank's going to harp on this too, because even if they're allowed to bring in the fact that he was fired, nothing in what that they found, nothing, zero, shows any conspiracy, cover up, planting of evidence. They fired him because he said some mean shit about her in his personal messages.
Well,
but none of what they found, and they went back, I think it was like 4 years or something, in the devices, nothing of any sort of cover up or collusion. Like,
well, I want to say, like, you know, you can't really claim that the force is corrupt when they fire a guy because he talks, you know, he basically talk shit about one of the people in trial, you know?
Yeah. I mean, come on now. Like,
I think it's going to be a tough thing to say.
He's not going to be allowed to, Ashley. Even though he's not an officer anymore, you still can't say certain things. And talking about privileged material is not one of them. He's not going to be allowed, nor would he could be sued later on for it. So
no, I don't. I mean, you can't talk about privilege. Like, what do you mean privileged material? What did it say?
You saw a privileged text message between Karen and her attorney.
Oh no, that's saying you can't talk about that.
He's not going to be able to talk about that.
And you wouldn't want them to talk about that. I mean, you don't want people to be presumed guilty because they got an attorney. I think it's actually I think if you ever have a situation where you're dealing with officers, then you have to basically get an attorney.
Lock on your phone. They got to get a warrant to open it, you know?
It's like, him innocent fraud. No, I'm not innocent fraud.
What?
I guess
innocent fraud like a female?
Yeah, sure. Innocent fraud's a female.
Like what? I'm pretty sure.
No, I mean, like, I'll tell you how I got in, and like, I actually looked into this case because I heard about like this district attorney shit, like saying about the harassment, and I was like, wow. And I was talking to my friend Queen, and I was like, wow, this is a pretty interesting story. And then I started looking into it. And at first I was like, oh, it's a little weird and inconsistent. And then I talked to other people. I started listening to Kate and stuff like that and looked into it. I was like, oh, okay. And I couldn't believe like the BS that was happening. And then I knew the glare because he was into the Krama community type of deal where he would attack Bullhorn. You know, he basically shit on Bullhorn Betty, made fun of her. And then one night he got extremely drunk on morbid
because
stream.
The whole case, hold on one second, because the whole entire case is innocence fraud, Rogue. The entire case is based on innocence fraud. So that's exactly why my picture for today is at courtroom and says innocence fraud, because the entire case is innocence fraud.
Yeah. I'm not innocent fraud. But I just jump on, just like, you know, just like other people jump on. So basically he got drunk one day at Galera on this morbid panel, started talking about choking, you know, he got off choking his girlfriend or whatnot and all that stuff. And he fucked up and he said, just unsubscribe. A bunch of people unsubscribed. And then someone recommended this case to him. I think it was Deets on the Streets that recommended him this case to look into. And he just shilled the hell out of this case like crazy. And he invited Turtle Boy and he really saw the numbers pumping up. And then one day he decided to I started laughing at him because he was being ridiculous. And then one day he jumped on a panel and challenged me to a debate. And then I did a simul stream. I had Queen simul stream his live stream and I jumped on and it was like, I don't know, like a year and a half ago. And he looked like a complete idiot, a complete utter idiot. And I made him look very, very stupid. He didn't know about the kid interview. He thought I was just lying about it. And this is what I was actually using Goosey, Sleuth Goose, whatever stuff. And I still beat him. Yeah, and I still beat him on a debate. And he kept on trying to state ridiculous things here and there. And he looked very stupid. And I followed the case ever since. I really just
those are the ridiculous things that he says is like things that have been completely debunked anyway. Like, oh, the taillight was on top of the snow. False. Never happened.
I think and then at one point I said, you know, I was getting annoyed because he cursed me out. He literally cursed me out on the debate.
Shocker.
And I was like,
he does.
It was getting a little ridiculous. And then and then when I says like his arm they tested the arm and they had no K9 DNA. he didn't believe me. He started playing Jeopardy music, and I'm like, I'm done with this. Like, you look stupid as it is, and I'm done with it. And
you don't want to why? Because that's his way of sort of like interrupting the flow of information he doesn't want other people to hear. If you say that, then he has to say that you're an idiot and you don't know what you're talking about, and like that never happened because he knows better, and then like interrupt you with nonsense and saying stupid shit. Like that's his like, and that's why nobody bothers to like even. There's no point in trying to debate an idiot.
No, but he looked extremely stupid. Like a lot of people, even like I had people who in the Karen Reed movement jump in the Queen's chat and says, you should debate someone that's not an idiot. It's like,
right. I mean, he debated Matt from Boundless Millennial. He looked like an idiot there too. Matt spitting out facts, and he's like, "No, that didn't happen." Like,
yeah, it's like they were like clearly. I mean, obviously there were people that simping the fuck out of them, but there were people that were like legitimately like, you need to debate someone that's not a complete idiot in the Karen Reed movement. I was like,
no shit. It's like there's no point in debating someone that's just going to like lie about every single thing. Like there's just no point. Like they're going to make themselves look stupid one way or another.
It was a bit of a shit show too, because it was like a mix of like true crime and like drama debate. Like it was pure because we were both fucking just going at each other.
It was a shit idiot. Let's just throw that out there. That guy is an absolute friggin' moron.
Oh yeah, he's very stupid. You know when he's like in real, like he always brings the blue cup when he's mad.
He loves to take shots. What did he say one time? He's like, "Oh, how's the hotel?" And I'm like, "Listen, you think it's funny to make fun of like homeless people? Number one, a hotel is better than your mother's basement. Let's just throw that out there. Number two, does this look like a hotel to you, sir? Like asking for a friend. Like,
I mean, the guy is a creep. I mean, like he literally, as soon as his friend broke up with his longtime girlfriend texts him, and then he sends a dick pic to her.
Shocker.
Just to try to take his longtime friend's girlfriend away from under his back, behind his back.
Easy Stevie shit, bro. Like,
yeah, I just think the guy is just like a trash bag human being that'll do anything for views.
Probably both of them, Maui, in my opinion. Both of them are idiots, but the Glare likes to try, like he sort of copies the sewer turtle when it comes to like thinking he can just like disparage and talk shit about everybody. Like, bro, you're in your 40s and you live in your mother's basement, and your last job.
No, he's not 40. He's like 50.
Whatever, 50s, and you live in your mother's basement, and your last job was a pizza job. Okay.
Yeah.
You have nothing on. Even if I was still homeless with my family, my intelligence and resume speaks for itself. I worked in a prison for the criminally insane. You worked at a pizza place.
Well, this is just the same type of job then. It's the same job.
Pretty much.
You're in a prison with the criminally insane. Now you're actually in YouTube dealing with the criminally insane.
Either one of these people would shit their pants on being as close as I literally work with inmates right here. Right here. Right. I'm in the unit. And I'm locked in the unit with these people, just like a regular CO would be.
Oh,
right there.
Back?
They would never, I guess, they would never be able to deal with what I dealt with. They'd cry.
And not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I can, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job.
Yeah, she was pissed last time with the last scene.
To a minimum.
Yeah. But somebody had to have asked her to make this instruction.
Yeah, probably defense.
I just need a witness. Yes.
Absurd. Oh yeah, he will be eventually one of his next targets. He's just too stupid to realize it.
All right, I gotta go. I'll see you.
See ya. Thanks, B. Tim.
No problem.
Certainly.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
No,
Good afternoon, Ms. Hyde.
God help us.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
What?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard,
Not allowed to talk about it. Sorry.
do you recall
You tried
another
anyway.
case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you
Objection.
took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent, I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
He's an idiot.
Page 15?
Sounds like an
Page
idiot.
1529.
The report
Judge,
is.
Would you like the
Just
page
allow it.
report or the page NDA number at the bottom? I can do either
Oh,
one.
I'm sorry.
Anyway.
I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way
Page
is.
7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top, it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower.
Right? We are.
I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart. And this is the key part.
Okay.
It says from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no. I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Object.
That's
Can
not
you answer that?
what?
I'm sorry, can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to
He's attempting
slide
to
82,
get one
please.
over on the court right here by saying, is that correct? Only taking a part of the sentence. Like, you read it correctly.
And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red. And this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us. He said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. You know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and
You can't speak to that.
do you have any
Objection.
basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be
Objection.
accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is,
Objection.
you make a statement. Well, let me back up. Do you understand
Well,
that in
Whiffen
this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a
He sounds like
decedent.
an idiot.
Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12:20:50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a
Your
lock
face.
button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
isn't the interaction with the device a lock
Not what
button
she asked. She was
readily
asking you.
available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
I don't know what he thought he just did there, but whatever he thought he didn't do. She can't comment on someone else's report that she wasn't asked to look at those things for her part in this. That's
If
what
you
Mr.
could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please,
He is a
to
windbag. He is.
go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
That says
So in the conclusion,
expert.
you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps,
Road.
audio playing, text
Road.
messages, and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis? I
Do you believe that statement is correct or incorrect?
believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Is he all right, dude?
Can you give me my page number, please?
I will. I'm
Okay,
just.
thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads, includes steps And the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen in steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from
No, it
your
is.
report, correct?
Your interpretation that 1232 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
He sounds like an idiot.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not, I
if I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which, just doing the simple math, is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mhm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says.
It's report 3, I believe, is what.
Exactly.
Yeah.
It's 3. And there is bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7, and let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for
Absolutely.
that time?
And
I do see an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29th, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May
Correct.
of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover
See her
that
face?
issue.
Sure.
Let's
She just looked at him like, what the
your
fuck?
May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words.
Oh God, here we go.
that
Word salad.
Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And
Not in the context.
in terms of page 3, if you could go back, of your report, under relevant findings,
Mhm.
it starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely,
right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to
Yes,
me as
you
Jennifer
did.
McCabe.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
And do you have a different conclusion as to whose
I
device
have-
it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is
You just
the
explained
phone
it.
of Jennifer
Objection.
McCabe?
That I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tully, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those two search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct two potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those two timestamps.
Right, so we're just talking about two times, 2:27:40 and then 6:23, is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough, so you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly, and that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die in cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern local time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it.
They should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
And that's relevant now.
11:23 is UTC, so its equivalent in Eastern time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those. And the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So in terms of...
He's arguing a typo. That's
your
like, what?
May 2023 report, your first report in this matter.
Yes.
Bro, just the floundering and the word games, like
you on page
proved
5
nothing thus far.
in the sentence underneath the block paragraph state, in the instance of the Google search, how long to die in cold that was recovered from the write-ahead log associated with.
That's correct.
The
Hi,
X
Dale.
browser state with
Welcome.
a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead.
Everybody welcome Dale,
to
the newbie who just found us.
Page 7 of your report. Up at the top above conclusion.
Definitely.
Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the
But you're not
definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if your honor would like, I will do it, but I'm going to start and then we'll see how it goes.
Oh, dear Lord, make it stop. Somebody make his voice stop. He's not even making any logical sense at all. He's literally going, you said this? Yep, okay. What point was that made?
Give me a moment.
What points has he made thus far?
Do you recall in that testimony
what is happening right
stating that you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you use for this timestamp?
I do.
And do you
Look at the judge.
recall
Look at the
stating
judge.
that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the tools I used.
May I approach, Your Honor?
Yes, Mr. Lessie, you offered a transcript. Do you have the whole
I have
transcript?
a whole transcript of that. Helps.
It might speed things along.
Agreed.
Okay.
We have one out provided. In the time is high, I'm going to leave you a transcript.
Thank you. I appreciate it.
Cleo, I'm over here like, send help with in the form of anything that can plug my ears. In the form of anything that makes it stop. He hasn't made one single point yet. Other than, did you say this? Oh, you said this. Okay. Did you make a typo? Oh, What points have we gotten?
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. Did
You're
I
just going
read
to keep
that
reading what
correctly?
she wrote?
And then going up to
Out of
page
context?
114, line 5.
Slow down a little bit, Mr. Les.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114.
Why is he just reading her
17,
words? I'm confused and she's
The Sanderson
confused.
tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now, if we can go to page 124 of the very same testimony.
I'd be objecting because I don't know where he's going with this. Why are you just reading back to her own words without asking a question in between, and you think you're going to use them
And
all as one
feel
thing?
free to go back a
I'm
page
confused.
just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with how long to die in cold. Do you
Can I
see-
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
That's his point. Is he's not giving the context. Like he's taking all of her statements out of the context they're in.
Okay,
and
I'm
trying
good.
to make
Thank you.
one
You're
context.
welcome. So what I want to do is start with page 1-23, and this is your testimony.
Exactly.
On line 16.
Mm-hmm.
I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search, how long to die in cold, in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now,
My
if you
frustration
turn
is
the
associated with your
page
face.
of the testimony,
My frustration is associated with your face and voice. Let's see. Make it stop.
you
Or make a
state
point.
back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Not one thing, you said it could be lots of things.
She's
correct?
confused. What are you
That is
asking?
correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testify, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that give in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So
Right.
you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now
Get out of context.
let's
go.
keep going.
Mhm.
Objection. He's just reading her words. He's not asking questions. Objection.
If you go to page 129 of this transcript,
It's question and answer. Objection. Objection.
I'm there.
at the
He's
top,
confused.
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab
A
being
tab,
minimized.
not a search.
The
Oh,
next sentence.
you dumb.
I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to
I don't know
page
why Brennan's
130
even
of your
letting him do this.
testimony.
I'd be objecting.
I need to object.
Look at her face. He's just reading it to her.
I'll see you.
And I don't know why he let it go on this long, because he's not asking any questions. He's just reading her own testimony out of context and not making any sense whatsoever at all. I feel like Aaron O'Keefe right now. That was fucking torture. Just listening to him. We needed that little break. Do me a favor, you guys, because like I kid you not when I say like I don't know how much more of him I can handle. Like in his nonsense, not even making sense. He's not even making any points. He's not even asking questions at this point. He's just going, correct? Is this what I read correctly? And she's like, yeah, you read it correctly. Like, what? Okay, so do me a favor, hit the like button if you didn't already do that. There's 300 of you. Hit the like button. Hit the subscribe button if you didn't do that already. Do me a favor, if you can. We have multiple ways to help out the channel. We don't have monetization. We're not as big as some other channels, so we don't have super chats and super stickers and membership. We're working on it. YouTube is slow. We're trying. But the best we have right now to support the channel and to help us get through this trial is Cash App, Venmo, PayPal, Revolut for those of you who are out of country. It works for all over the world to send and receive. Obviously, there is an option for e-gift cards. People send those to me sometimes. So we have all those options for you guys. And sorry, I'm just looking at something. My brain right now wants to like refocus because of him. Maybe I need to do like the Jackson finger countdown to calm myself. It's kind of soothing. I'm not going to lie. This is crazy talk. Like one juror is looking at her fingernails. Another yawns. At least two are taking notes. I don't know what notes they could be taking at this point. Like 2 reports on X that the jurors are yawning. One juror is looking at her fingernails. Another yawns. At least 2 are taking notes. This is amazing. Amazing. Yeah, they're probably doodling because that's what I would be doing is literally doodling. Like, I can't. I don't understand. I would probably be doodling, make it stop. Just like over and over. Like, make it stop, please. Like, please make it stop. I cannot deal. Like, she is very good, Crimson Crime. I agree with you. Because all he's asking at this point is, did you read that correctly? And she's like, yeah, you read it correctly. But he's just going page after page after page of things that she said, but not asking any questions. You can't then take everything that she said and said, well, isn't this true? It's not the context it was in. And ultimately what's going to happen is she's going to say, well, you just gave me 20 things that I said and each were asked in a question. Each a different question that I answered pertaining to a different thing. Like, is that for like what? You're a lawyer. You know that you have to ask questions. You know that you can't just read their testimony. That is not correct form at all. Not proper. Like, I mean, she shouldn't have to be a preschool teacher, dealing with a twin. This is crazy talk. Like, he literally did. Like a dumbass. Look at her face. She's like, are you done now?
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and get some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages, and bear with me. I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here, what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and you were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold.
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. All righty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have the chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools.
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director
Rude.
of forensics,
That is correct.
still shows that timestamp.
Yes, yes.
But Celebrite doesn't. In the
That
audit.
is
She's like, what's
correct.
the point?
That is
What's the
correct in
point?
their automated parsing.
And you would agree
What's the point?
that Magnet Forensics is a very reputable company, correct?
Correct.
He's just proving they removed it for good reason. Wow, he's a dumbass. Wow, someone fire him. If I was defense, I'd fire him immediately.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct. Yes.
However, in December of 2024, when you returned to analyze the 2:27:40 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it.
Thank you.
You're welcome. In this
called him out.
report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes
The
that come out?
release notes at the bottom,
Perfect.
right? You referred
I'm
to
there,
that.
Eva, but I
That's
can't
correct.
see away.
And
I'm stuck.
that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down all the way down to the conclusion. In
Into
that
the nose.
report,
Oh, dear.
is there reference to any company other than Celebrate in this entire report? Is there?
In this report, no.
Okay, thank you.
What was the point of that?
Now
Once
let's go
again.
to
What?
your prior testimony
I'm
in the
stuck.
first proceeding,
Me.
where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now, let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
No worries, sir. Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed
Objection,
source.
trying to
That
get
would be
into
the
the
term
other
of art,
stuff.
correct?
And
By going
it's
around
so
it.
close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I referred to that as the MB postulate, it's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple's source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't perform operational performance.
Apple source codes.
Not necessarily. Because that doesn't perform operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a
I have
question.
not had
Have
that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
Sorry, we have to wait for each other.
Oh, yes, I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report,
She already said
especially
that.
since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history from the extraction of Jen McCabe's phone? It's yes or no?
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but
we all need to be paid for this torture.
Released this January.
All of us.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is and what make and model that device is and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was
Objection, don't assume
deceased
anything.
around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time now? Yes. Thank you, Your Honor. So bear with me. It's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So,
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So,
I'd be quiet if I was Brennan too. He's sinking, unless he's sinking
the
himself.
iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this. As
So
would be
you're
the
saying-
best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or a Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, we in this instance,
Don't need it. He was
It doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday.
that
I
wasn't my
100%
question.
agree.
You wouldn't
My
Faraday
question
someone's
wasn't, is there
phone
more
who
or
is
less
not
data? My question
live.
is simply, doesn't your own report,
So
your
she's not a
own
police officer.
report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yep.
There is activity on
Absolutely.
this phone,
Absolutely. The
which
phone,
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
correct. It is not in accordance
Thank
with
you.
the best practices. I agree. I would have Faradayed it.
Thank you.
But she's not a
So-
police officer.
If I,
But that's
presuming all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
What questions?
Let's redirect.
Thank you.
Yep. Please, Mr. Brennan. What is he doing? What is he doing? Look at his face. He's like, are you done, you friggin' windbag that just tortured everyone's life? I did see a $5 donation come in the other day. See, this is where my brain's going. A few minutes ago while they were talking, so I appreciate I'm not going to say the person's name, but thank you very much.
Of course.
He's not making any points, and also he's not making any sense at all. He had no idea what he was talking about. Dear Lord.
Whenever you're ready.
Thank you, Mr. Green. You're welcome.
He's like, get the out of my
You
way.
were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
I
May of
almost didn't make it.
2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SAL was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And would you inform why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No,
When you engaged in your analysis, was it independent of the district attorney's office?
my analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No,
Would you ever allow anybody to affect your input?
no.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes,
The report regarding report number 3, regarding changes to Celebrite, software. Was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrate software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrate's own statement?
Please.
Celebrate's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that. Can you repeat the question? Now?
Was there any reason other than the concern about misinterpreting or distorting?
They said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrate give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide. And that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context to you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari PLIS, which tracks the history, as well as the Knowledge CDB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari PLIS.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022,
That is correct.
page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion, you could be on a bicycle, you could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor. I'm going to deny that question.
Can these health steps occur
Deny
if
that
somebody's holding
question?
a phone
Not a
while
Proctor.
traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you on cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So
That's beyond the scope of the class.
It is not beyond the scope of
It was
cross.
pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that began at 12:31:56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
And so that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at
That's correct.
12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyze the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04?
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr.
Yes, thank you, Your Honor. We have a moment, Your Honor. Excuse me. Go ahead. There you go.
Thank you.
Oh, for fuck's sake. Someone. Oh, I can't.
Ms. Hyde, you were asked questions by
Can't do it.
Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the,
Thank you. I appreciate it.
and I'll repeat the question.
Thank you.
You repeat everything anyway, you freaking windbag. Anybody who thinks he won today needs to seek help immediately. Like, immediately. Immediately. Dude had no clue what he was even talking about. It's very abundantly clear. You see the defeat in his bald spot.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other.
I'm sorry, my
but
question
not
is, do they
Celebrite?
state in the release note whether there's a reason for why they concluded?
May I look at the release note, ma'am? Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the
Asking if they give a
conclusion,
reason is asking you to
not a
read it.
reliable timestamp.
One moment, I'd like to review what they wrote. Thank you.
Absolutely. You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
But he knows. It's
that
this
is
case.
correct.
You
They
All right,
state
now what I'd
idiot.
like
it's
to do is
unreliable.
move
That's why she said
on
but.
to Axiom.
But
you were asked questions by Attorney Brennan, and you referred to Axiom
Yeah,
as
whatever you
using
do,
a different
don't read it.
parlance of, with the timestamp of carved, correct?
Celebrate uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
it's the
currently,
opposite.
Celebrite doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Not sure
And that
what-
phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m.
She
on
cannot
January
tell you
29,
that.
2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock.
Airplane
My
mode.
report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
I don't know
It
what
would
he's
appear
assuming.
such. Because I didn't analyze
By
past
saying
that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
But you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6
and
a.m. to
I'm-
noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29,
They
2022
didn't know it
until
was a
at least
homicide at that
noon
point,
of January 29,
so it doesn't matter.
2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but in 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions.
I don't know what he's getting at here. Is he saying something is incorrect in
With
John's
regard to
phone?
the iPhone of Jen McCabe.
Because this doesn't make sense at all. What does it matter if John's phone
Do
was
you
Faraday?
have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto deletions because
Yeah.
I don't know what that
That
is
means.
inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but
Not
were
from the user.
recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday,
Could be a log.
you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
Like, what are you talking about, buddy?
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again? I
Absolutely.
apologize. There's
Oh, no.
a lot of timestamps going back and
Please
forth.
do.
12/31/56? Is that
Yeah,
the?
that's the start. Yeah.
What are they saying? John's phone
yes,
was
this
moving
one there
after 6?
definitely is.
Yeah,
Yes,
he
yes,
was
yes.
already gone.
So,
What's that
doesn't
mean?
matter what kind of movement,
What does that
but
mean?
that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022,
Yeah.
correct?
Yes.
Thank you. Appreciate again you answering my questions.
Thank you.
That's when he was hit and stopped
Thank
moving
you, Your Honor.
forever.
Or I see counsel about scheduling. There's something-
Oh my God. This has been the most like mind-numbing day of my life. OMG. My brain's
Okay.
gonna explode, I feel like.
I have 15 minutes.
Okay, go for it.
Here is Bob Alessi's entire...
Oh, wait, we got a clip. We got a clip.
Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Oh my gosh!
Alright, so folks, I talked to the lawyers briefly about scheduling and sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow. Now you will see the lawyers at Sidebar asking for as well about talking a bit about scheduling. So same cautions, please. Do not discuss this case with anyone. Don't do any independent.
All right, we don't need to hear her say the same three things she says every day. Oh my God. Now the jury has to go home listening to It's Me or You, Jen McCabe. That was fucking brilliant. Go ahead, Bree. Sorry.
I was just going to say, every single thing Alessi just said, everything he tried to insinuate, everything, every time he banged on that podium, and why she keeps letting these male lawyers bang on that podium to female witnesses, I don't know, but she better knock it off.
Yeah, that's crazy. Triggering too.
Can all be summed up in one sentence. I do not know what the fuck I'm talking about, but I'm going to stand here and make it sound like I do.
That's what he did. Legit.
All of this talk of source code is so completely irrelevant.
Yep.
You cannot save data to the source code, period. Can't be done. You save data to a storage device or storage mechanism controlled by the source code, which runs the operating system. You do not write data to your operating system, ever. Because if you could, not a single computer on this planet would function.
Thank you. All he did was read her own reports and then try to mislead people on what it meant. And I'm not even sure what he's implying. You're implying that John's phone wasn't put in a Faraday bag. So what? What data are you disputing? Are you disputing her voicemails? Are you disputing the text messages? What are you disputing as data that could have been overwritten or changed? Because there's no, like, what? Like, if you want to dispute something, maybe Jen McCabe's phone, but what are you trying to dispute on John's phone? It's utterly ridiculous. He has no idea what in the actual F and F he's talking about. This is why she said I'm uncomfortable with words like auto delete. What are you implying it means? Are you saying auto delete as in she deleted it, or auto delete as in the phone put it in the background of the data set and it took it off of that screen and put it in the background to delete? Like, which one, sir? Because I'm not answering that. Poor Peggy.
And Aaron says, he's trying to point out that having access to the code lets you evaluate data better. Now, it's been a minute. It's been about 20 years since I was active in software development. But I can tell you that at that time, I was a developer on a content management application framework that ran on PHP and the SQL database.
Yeah.
And we were open source. So everybody could look at our source code. Everybody could contribute to how the framework functioned. Reading data stored on that framework had nothing to do with us. That was all user input into the database, not us.
Absurdity. Monarch, I'll answer that real quick. The court has told people they cannot rebroadcast the Zoom, which is via Karen Cam. Law and Crime's not playing it anymore. And they have told people that they cannot rebroadcast the Zoom. So I don't really know why Grant's still rebroadcasting and he doesn't have the permission to do it. Nobody does. The court said to stop rebroadcasting it. So we have not played it here for that reason.
I mean, the entire thing was just absurd. He is trying to lord over her from his 5'1" lifts, and she's talking back to him. Literally, I had 5 minutes before that diffused a meltdown on a 5-year-old, and it was the exact same tone of voice.
Right.
And then she turns and she looks at the jury right before that sidebar, and I love that this was captured because she looks over at them with this incredulous look on her face, and at least one of them responded because she nodded and smiled at them. At the jury, they were commiserating with her in real time about what she was being put through. That's not good.
No, definitely not good. Definitely for sure not good. I mean, he was floundering. He had no idea what he was talking about. He's she's like, that's not a thing. You're conflating 3 separate things. You're talking about parsing the data, right? And then data tools. These are different things, different concepts. Like he's using the word data or tool as in it applies to all three of those things. It does not. And he had no clue what he was talking about, so he couldn't ask the proper questions. Shocker, huh? Same thing he did with the meteorologist, which is kind of funny if you're supposed to be an environmental lawyer. No? Yeah? No? Just saying.
Very funny. Very funny. I mean, seriously, any case that these people have ever won using Celebrite, Axiom, any of them, every decision ever been won on every single one of those. If what they are asserting now were in any way remotely true, every single person ever exonerated by it would be put in prison, and every single person ever imprisoned by it would be exonerated. You can't do that.
No, you cannot. Hold on, we got B-Tim. We got to add him in here. Oop, wait, what's happening? Oh, there we go.
It's
Hey, there he
you.
is.
It's you or me.
That was great. That was freaking great. That was the best thing ever.
It's you or me, Jen McCabe.
Oh
Like,
my
yeah,
God, Billy's
okay.
gonna sit on that like till
Either
tomorrow.
I'm going down or you do. That's a threat.
Yeah, it
Oh
is.
my god. And like, was I right about Leslie making himself sound stupid?
Oh my God, so stupid.
Yes.
That's the
So
problem.
stupid.
It's like you're gonna try to get into this really intricate data, and you're not gonna understand it. You're not a tech. You know what I mean? Like, there's a huge difference between being a lawyer with an environmentalist or whatever the hell he was doing, and understanding like this type of technology where there's very few experts. Like this type of thing, I honestly think he needed like to probably, if you were going to go through this guy, you need to hire your own advisor, like someone just as smart as her to kind of write your questions.
Oh,
and I don't think he did that.
He did not.
He's talking about a Faraday box. I'm like, what the fuck are you
Faraday
doing?
bag in a Faraday box, but that has no point in John's phone. Like maybe Jen's, sure, if you want to, but she handed hers over willingly. This person is deceased. What need do they have to put it in a Faraday bag?
At
Or
that
box?
point, I was waiting for Zach Bagans' Faraday cage to make an appearance. I seriously was.
I love you. I love you so much. That was a great one, Stacey. She said, that's not a valid question. Like, that's not even a valid question, guy. What are you talking about?
And then he's like, "Oh, did it go? Did it do the Apple steps at 12:21 or whatever he was saying?" I'm like, "Bro,
exactly.
He was in
That's
the
when he was hit.
car. He was
No. Oh, the 12:11. Yeah, 12:11. That's when he was in the car. But she's like, it stopped moving forever at 12:32 and some seconds. Yes. Okay. Yeah. He was hit at 12:31 and some seconds or whatever. He probably stopped moving completely around 12:32 and some seconds. What's the point?
Here's the thing. Human bodies aren't flat. When we hit the ground, we either roll or bounce.
Yep.
And that could absolutely take those 20 seconds that he just did that entire recross on.
I have a question. Did they mention a cat in this? I didn't watch all of it. Did he mention a cat in the cross or something at one point?
The cat was yesterday with the meteorologist because the meteorologist used the phrase like enough snow to track cat paws, like enough that you would see like the paw prints basically. And so he kept talking about the fucking cat yesterday like an idiot. Like I can't. Yep, here's the exact times right here. Freak has them. So 12:31:56, 12:32:16. So you want the jury to believe that what? There's
I
some
don't
issue.
know. I honestly think pursuing this whole Jen McCabe's phone thing, because I think the reason why he played that is the consciousness of guilt. Because I think Mr. Hank is building a case for, basically stating that, the witness intimidation, them going after the phones, all this stuff is basically her big cover up.
Right.
And I think that's a possibility. I think that I'm having that feeling.
I did catch that too, Jane, when they were saying that John's phone had ring notifications going off on it. And I'm wondering if this is how they know that certain videos were deleted, is because he had ring notifications going off on his phone telling him when each thing was happening.
It would have to be. I get them all the time.
Right.
There's a movement by your pecan tree. There's movement at your front door.
Right. I used to get because mine was also like motion detection. So like I shut off the notifications after a while because my neighbors coming to the door to get in, and it'd be like sound notification, movement notification. You get one for each. Like, so boom, 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 just going off and off and off. And I'm like, oh, F this. This is annoying. Like,
I just think today was not a good day for the defense because, like, I feel like Alessi is horrible. He's just horrible.
he is horrible. I don't know why anybody over there has not grasped the fact that he is that bad yet. Like, I do you live in that much of a delusional land? I mean, at one point, I did see Elizabeth Little looking at him while he was arguing that thing with the judge. Like, I think you went a little too far there, but I was looking at her and her face was like,
yeah, like you're arguing things that should, like, I think like they're bringing in the report about, the whole that I think that's admissible. You know what I mean? Even though it's unrelated, I mean, you can't really stop a guy from using it. I think it's a mistake.
In the beginning. Did you see him? He went right for it after the judge told him no, and she's like, "Yeah, you're gonna have to move on from that, Mr. Alessi."
Yeah.
Like,
the problem is, I think he would have gone into a trap if he did go into there anyway, because he just doesn't understand. It's like you're going to go with a complete, like with this type of expert, you're going to fall into a trap of sounding really stupid, which he was in the beginning as well. I mean, he was tripping over his words constantly.
He didn't even know what he was talking about. That was half the problem. Is like Jessica Hyde's like, that's not a thing. Like, what you're asking doesn't make sense, basically.
Yeah.
So like you're letting the whole courtroom, including the jury, know that this man has no effing clue what he's even talking about. Like,
yeah. It was very apparent. That's the risk you run when you are an attorney. You ask a question you don't know the answer to.
Never do that. That's friggin' lawyering 101. Don't ask an answer that you don't know at least little bit the answer to. Don't do it. Like,
here's my last point because my break is over.
Yes, ma'am.
Since we had to watch that clip after Jessica Hyde instead of Jen McCabe, where it belonged, and if Bev doesn't get her elbow off that damn scale of justice, I'm going to have a serious issue. But I could not have imagined a better lead-in for it than the defense reinforcing the fact that after John was hit by that car and his body stopped moving 20 seconds later, he never moved again.
Yep.
So thanks, Bob.
Yeah, I know. I said the same thing. Like, thanks, Bob, for making the point. Dumbass.
And I love you, and I will be in chat.
Okay, bye.
Yeah.
Love you, Tim. I love you.
Don't. And like people are like sitting there, it's like, oh my god, Alessi nuked her with that. It's like, bro, I don't think you quite. I think like a lot of the people are pretty dumb.
No, I think this is the problem. This is what happens. They hear, like, specifically even in last trial, right? They heard Jessica Hyde say 2:27 a.m. and immediately in tweets they're like, see, she said 2:27 a.m. They listen to nothing, nor do they understand half of what she's saying. Not that I'm expecting that most layman people are going to understand what she's saying. This is more tech stuff that like people who know tech like would understand. My brother has taught me some of this. So like I followed her, but not everybody's going to, and I don't expect everybody's going to. But what I do expect is if you're not following her, to not try to make points on things that you have no friggin' idea what you just heard. And that's what they do.
And I was also interested. He was asking her to review, like, comment on other people's reports. Like,
yeah, that was strange. Like,
it's like, which is like a big no. You can't. Unless you're asked to review it, but like she's not going to review other people's reports. You have to. You had your chance to ask those questions with the other witness, and I just think, I don't know.
I don't know why Hank didn't object to that, or the judge didn't move him along. Though she cannot testify to someone else's report. Period.
Yeah, if it
was Hank, the judge would have stopped him right away.
Yeah.
Hank. Most people don't have to. Unfortunately, I have to because you guys depend on me to tell you what happened. So I don't have the option to just like click out and not listen and like get up and stretch and maybe, go do some jumping jacks, unfortunately. So that was mind numbing. I'm not going to lie. It was torturous. I think it's a form of torture at this point. I'm not going to lie. Alessi himself is a form of torture, but that was absurdity. Like I think everybody here who watched that thing should be paid money because we can never get the time back that we just spent listening to that nonsensical nonsense from him. Like, for real. You cannot get that time back.
Yeah, it was just but yeah, I think like it's pretty much proven that the 2:27 Google search did not happen, and
badgering her about it.
And I think that this kind of shows you when you look at Karen Reed and how her body language is at and how she's basically just acts like how she's doing, and then you hear that last clip of "It's me or Jen McCabe, it's me or Jen McCabe,"
So
you
bad
really
for her.
get like a picture of someone that is. This is not good, and
No.
I don't care which Lawtuber says, "Oh, it's a good day for Karen." I was like, bro,
No.
I would love for any of these Lawtubers to explain even a quarter of what that woman. You know what
They
I mean?
can't.
Like,
They
no,
not
they
only
can't.
can they not, but what I find funny about it is I want you guys to pay attention today on how many of these Lawtubers try to say that Alessi did a good job. And then I want you to disregard everything they ever say ever again if they say that, because they knowingly would be lying to you at that
Yeah,
point.
I mean, at this point, if you think the 227 call, like the 227 Google search happened and she's looking, then I think you are just completely disproved. Like, unless they bring in some sort of expert of the defense, like an amazing expert that just disproves both of these expert witnesses.
The
I
lawyer
think,
said that. Of course he would. He would say something like that.
what did he say?
He said it was great.
So sometimes, yeah, I don't agree with that. I think, like, honestly, I don't agree with that.
Wait,
I think
Krowski was in the courtroom? Ooh, that's interesting.
Oh, okay. But like, why would he think it's great? The 227 time never happened.
No.
So the whole cross was to prove that the 227 time happened and to prove that the steps or something happened or whatever, or try to disprove these people are not good experts. But in actuality, they were proven to be good experts and they proved that the 227 Google search did not happen.
You know what else he did while he was up there doing that amazing cross that the lawyer thinks was so great? He lended Ian Whiffen more credibility by asking Jessica Hyde if she thought he was extremely credible, which was such a effing stupid question to ask. Like,
yeah.
Like, thank you, Alessi, for lending that credibility to Ian Whiffen when he's not even there. You absolute idiot. I would have fired him day one if he was a part of my defense team. I don't know who suggested that he should be on the defense team, but like, dude is not good at this. Whatever it is that he's good at normally, cool, great. But this
I mean,
is not his thing.
if these lawyers think Karen Reed's defense is doing a great job, I think they're incompetent, to be honest with you. Any lawyer will tell you that having these statements being played in court, having a docu-series is malpractice, in my opinion. I consider having your client on a docu-series making these incriminating statements multiple times while you're in the room is malpractice. I would think that she would have counsel. Like, yeah, I mean, like, this is malpractice.
But she signed away her right to ineffective counsel, so she can't even go for that.
Another issue is that you have Alessi, who is just nonsensical because he doesn't get to the point. And when he does make a point, a good point, it gets lost in the jumble, and no one knows what the fuck he was talking about. He's having her read all these reports and stuff like that. I don't think these are good moves by an attorney. I'm sorry. And the fact is, if you get, they're saying it's a good day. It's like, no, it's not a good day because they broke the first rule of being an attorney, is telling your client to shut the fuck up.
Yep.
Really?
And you didn't. And your client just ran her friggin', I'm not going to say what I want to say, but she ran her friggin' mouth right out the side of her neck, and you allowed her to just keep going and going. And you get clips like this.
Another issue is how she dresses and how she acts.
Yep.
No attorney would have their client look at their phone texting, dress up like a mafioso with the suit, look like she's going up and down to the bench. That is not something you want to do.
It's not good optics.
It's not good optics because at the end of the day, the jury is looking at your client and everything her face, how she reacts is being judged.
Yep.
And that's not good.
And here's the kicker. She knows that. She said it in the documentary. Everything I'm doing is being judged. I can't be sincere enough. Well, you shouldn't be trying to be sincere. You either are or you are not.
And that is terrible. So any lawyer that thinks these are good ideas to have your client dress up like a mafioso boss and try to not make her look a little bit like softer with color, like a dress, some sort of nicer colors on her, like a light blue or something like that, make her not go to the bench, like allow her to make incriminating statements on a docu-series.
Get her off the computer and the phone sitting there and not paying attention. Like you're worried about papers, a computer, and your phone. You're not even paying attention to the people in your own murder trial. Like,
I would suggest, if you think these are great ideas as an attorney, I would suggest you do not hire those attorneys as your counsel.
Please don't hire
like, unless you want to go to jail.
Yeah,
because
I wouldn't hire any of these people if you paid me money to hire one of those people. That's for sure. I would not hire the lawyer, I would not hire the DUI guy. I would not hire Melanie Little, like Nan. You couldn't pay me money to hire one of those people.
And the problem is, let's say that Mr. Alessi was making these great points about what's being analyzed and what's not being analyzed. Did the jury understand what the fuck he was talking about?
No.
That's the most important. You might understand as the attorney because you might have a higher understanding of this, but does the jury understand it? Was it so discombobulated that you basically lost the point and you didn't go into it just immediately into what you needed to cut part of?
Yeah.
And that's the problem.
Dale, the funny part about that is there's 18 jurors. So 6 of those jurors are not even going to deliberate, and they don't know at this point which ones are. None of the jury doesn't even know. It gets picked when it's time for deliberation. And so some of these jurors, even if they are FKR, they may not be picked to deliberate, right? And also, if they're showing any sort of bias at this point, they can still be dismissed. That's why there's alternates. So I do have a good feeling that Hank made sure that this jury wasn't, and I do think that he's making sure, even going forward, that his team is making sure that nobody's making social media statements that are biased and things of that nature, because as we saw in the first trial, a lot of them were dismissed for things like that. So,
well, Scorpio, I think the points I made with this woman made, the witness, Jessica Hyde, Miss Hyde, was that she basically said that you cannot delete your own messages. They had this whole thing, like not delete your own messages, but delete the phone calls. It was an order or something like that.
She didn't delete phone calls. She didn't delete anything herself.
The 620, the 227 Google search did not happen. And I think what's going to happen is that if they get their own expert going, I highly doubt that they're going to bring Green. If they bring Green, and that's
I just don't see them bringing Green at this point. The way they spoke when the judge asked them if they were bringing him on, it seemed to me as if they if I'm gonna say yes, Your Honor, that's the expert we're bringing. He didn't say that. He said we're bringing a expert. Well, you can't get a new expert, so either you're bringing that guy or you're bringing no one.
I think they're going to bring in Exion, the other one.
Maybe they had two, as far as I know, but
that's who I think they're going to bring on.
I don't think they're bringing Richard Green. I promise you that.
Richard Green would be a disaster.
Yes, just like Russell.
Yeah, I don't think Richard Green would be a disaster to bring that individual on. They need to bring another expert that is kind of like an Ian Wolfen or a Miss Hyde to basically support their positions. Because if they don't do that, then they're in trouble. But the problem is, I don't think they're going to have. If they bring in Green, they're done for. The two, you know what I mean? Like that. If that's
Green,
their.
And then you've got to get Marie Russell right after. That's a disaster, bro. That is like apocalyptic Hiroshima bomb explosion.
They need more credible experts on their side, because
I think this is why they tried Garrett Wing, though. I think they wanted to replace him with Marie, to get rid of Marie Russell and replace Garrett Wing. But in my opinion, that's not going to do it either. Nobody in their right mind is going to believe after the Commonwealth's experts that a dog did it. Okay.
Yeah. I don't believe, you never know with what money can promise you. I don't know.
Right.
But the problem is they need a better expert than Green, because basically the witness today said that he was worse than the first year graduate, like a first year person at school.
Yeah.
He got confused. He basically misinterpreted data. And
Jessica Hyde stopped short, but she was trying to explain, he was like, is there any other reason? He knows the reason. So any other reason that Celebrate gave for why they took out the timestamp. And that's why she looked at him and said, well,
because Mr. Green, mainly because Mr.
Because of
Green,
this case. That's why. We know why. And that's why she stopped, and he stopped her right there. But we know why.
Yeah. Basically they took it out because it was becoming confusing, and idiots like Mr. Green allowed a witch hunt campaign to Jen McCabe that still goes on to this day, even though you have multiple experts have said that the 227 time never happened.
Yep. and they're still just trying to make it. They're trying to make fetch happen when it ain't happening, dude. You know? Yeah. And Russell, she said she's the smartest dog expert in the whole wide world. Like, there's nobody smarter than her. Funny enough, she's not a damn dog expert. She's an old doctor that retired 20 years ago.
She's going to be torn to pieces on the stand.
Absolutely, 100%.
Mr. Green will be torn to pieces on the stand if he jumps up.
And now Arca.
If Arca comes on that stand, I think it was the worst decision by the defense to bring them on.
Me too. Worst ever.
Because I think they needed someone with clean hands that would present the case professionally and, you know, kind of, but bringing these guys on with what being biased as they are and having secret meetings.
Yeah.
That's not good, man.
And I also think that the reason they didn't, though, beat him is because nobody else, once again, would say it. Nobody else would testify to what they're trying to say. No one. No one with any credibility.
And they better have their reports. They should have had their reports by today, I believe.
Today.
Right?
Yeah, today. Yep.
So if they don't have their reports by today, I think there's some problems going to happen.
Oh, yeah. Absolutely. I'm wondering if they got those reports in. That's what I'm dying to know. Like, did they or didn't they? I also want to hear from the ring expert for the Commonwealth. Like, what's the ring expert going to testify to exactly?
Well, I'm more interested in the tech stream data from the fucking car.
I want to hear more data from the car too.
Because before there wasn't as much data from the car, and I'm thinking like if they got more data from the car, I think that'll be a game changer for a lot of people.
Well, we know they did get more data. We just don't know what that data is.
Yeah.
That's what I want to know. We know that they did get more. We just don't know what exactly they got and if it's useful. I would hope so. And I don't know. If I'm Arca, dude, I don't know why I keep Dr. Wolf employed at this point. I let him go.
No, I mean, like, I think in the end of the day, you have to realize that
he killed their credibility in the field.
The issue is like the behind the scenes shit is bad. It's not like the testing that got him into trouble. It's the fucking behind communications, talking to people on, you know, these things. It's just fucking weird. It's very
but if
weird.
you're also skewing your results because you're ignoring, you know, basic evidence like text stream data, and pieces of taillight, like, you are now not credible for anyone in the field to hire you, especially if you have your expert using Signal and then deleting these messages. That is not going to bode well for anybody wanting you to testify on the stand for them. Now, is it? Because that can be brought up.
I agree. I think it's not a good idea that what he did.
So I don't know how they keep employing him, to be honest.
Yeah, well, I mean, I don't know. Well, we'll see. I think you know, we're getting closer and closer to the more, because a lot of these experts we knew about what even happened because the last trial. I'm hoping to get more new information. Hopefully they have, but I can't believe they allowed playing that clip. It's me or you, Jen.
It's so great, though. That's so great because now the jury takes that home with them until tomorrow morning. And she says, like, it's either me or you, Jen. Like,
I mean, I can't believe like Lawtubers are actually saying Jackson and all these people did a good job on this case when their client is literally self-snitching on the trial. Like, honestly, I feel like that is a career-ending situation that you probably should never even be representing someone for a car accident case, to be honest with you.
Nope. Yeah, consciousness of guilt. Exactly. And that's, I mean, Hank hasn't even asked the judge to read the instruction of consciousness of guilt, but like, that speaks for itself, in my opinion. That clip speaks for itself. Like, that is a horrible clip. But what I really get pissed off about, I think Bree's right in this, is the judge shouldn't get to decide where the clip is played and how much impact it has. It's played where the Commonwealth puts it in their case. It shouldn't matter where. If it's allowed, if the clip is allowed, shouldn't matter where it is played. That is the judge putting too much of their finger on the scale. Like,
yeah, I don't know, but it is what it is. Well, it was good talk to you. Let's see what the shit show is going to be tomorrow. I'll see what happens.
All righty. Thanks,
you have to go on.
Appreciate you.
Bye.
All right, guys, I'm going to wrap it up too. I am tired and I'm hungry and I might want Chinese. I'm not going to lie. You know, Mark told me to get Chinese with his donation, so I might, because it sounds really good. I'm not going to lie. I haven't had Chinese in a really long time, so I may do that. If you would like to make a last-minute donation to the channel, we would really appreciate it. We've been struggling a little lately, especially with these longer streams. We have Cash App, Venmo, PayPal, Revolut for the people who are not in this country and who are all around the world, Chime, and then good old e-gift cards. If you need to contact me, you can do so at twistedtragedies3@gmail.com. You're totally welcome. I think sitting with that, also you can join our Discord. We have a Discord. We have an Apple Pay link too, for those of you who just want to use debit or credit and have Apple Pay. You can join our Discord and people talk about it, all day. So if you think of something new, you're like, hey, what about that point? Guess what? We talk about it in Discord. So we have a Discord link. If you have not joined our Discord, welcome on in. It's a very welcoming community. It's lots of the same people who are already here in live chat. But until then, I shall see y'all at 8:30 a.m. in the morn. And everybody have an amazing rest of your day. KK, bye.